Honorable Judges of the United States Court of Appeals in and for the 7th Judicial Circuit, hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. Welcome. Our first case for argument this morning is the United States against Alexander. Mr. Stanton.
Good morning. May it please the court, Mr. Mauer. My name is Bill Stanton, and I represent Tyquel Alexander in this appeal of a denial of a motion to quash, arrest, and suppress evidence. In this appeal, we contend that there was no probable cause to seize and search Mr. Alexander. The brief facts of this case are as follows. Around 1 in the morning on October 10th of 2020, Mr. Alexander was standing on a sidewalk in the West Garfield neighborhood of Chicago. At that time, there were approximately 30 other people standing on the sidewalk with him. A man walked up to Mr. Alexander and handed him an L-shaped object. Alexander briefly held that object before secreting it in his waistband. Chicago police officers were monitoring that area with a police observation device, or POD, camera. Officers saw this exchange on camera and proceeded to that location, arriving approximately 15 to 20 minutes later. Once officers arrived on scene, Alexander turned around and shuffled along a fence line a few steps. Officers immediately approached Mr. Alexander, placed him in handcuffs, and searched him. They recovered a gun from his front waistband area.
Now, Mr. Stanton, good morning.
Good morning.
This is Judge Rovner. My understanding from the cases is that even a very brief period of openly carrying a firearm is enough to support probable cause to arrest a person for violating a statute that prohibits open carrying. Why wasn't that the case here?
Your Honor, the officers who were observing this area via the POD camera did not know who Mr. Alexander was, what his background was, whether he was able to legally possess a gun, or if he had a valid FOID or concealed carry license. The state of Illinois, and I believe the statute that you're referencing under the Concealed Carry Act, does prohibit an individual from openly carrying a gun on a sidewalk. I would submit to you that if Mr. Alexander did have a valid concealed carry license and was handed a gun on a public sidewalk, his near immediate secretion of that gun in his waistband would be appropriate under the act to amount to concealing that weapon.
But it sounds as though you are conceding that even if briefly, it was out in the open, visible to others who might have been looking that way.
But
I mean, it's changed from one hand to another, that's all.
Sure, and there's ample video evidence here. Both the POD camera videos as well as the officers who arrive on scene have body-worn cameras. And I do think the video evidence does show maybe 4 to 5 seconds of that gun being out in the open before it is tucked into the waistband. Is that reasonable under the Concealed Carry Act? I don't know that the act specifically addresses the transfer of a gun on a sidewalk. It's kind of an unusual situation here, but I would contend that if someone's presented a gun in public, that secreting that gun within seconds would be reasonable.
What do we make of the fact that Mr. Alexander seems to have taken evasive action, too, as the police officers approach?
And that was one of the two bases that the district court relied upon in determining that there was probable cause. I do think the video's pretty clear about this, that police officers arrive on scene and Mr. Alexander definitely turns his back to them. He doesn't take off in headlong flight. He doesn't discard any objects, but he turns his back to them and shuffles.
Kind of sidles along this fence, right?
Shuffles along a fence line a few steps.
He also pushed against the fence, which might have made the police officers believe he was trying to escape into the house.
Your Honor,
I mean, there were there was a little more than just the shuffling, although I will tell you I'm not particularly impressed by the evasive movements, but they were at least, I think, consistent with the officer's perception from the surveillance video that he might have engaged in illegal conduct. And that would add some slight additional support to probable cause.
Your Honor, I believe that the point where he pushed against the fence wasn't a gated area or a hinged area where he could have effected some type of escape. I believe he was behind another individual at that time and pushing against the fence perhaps for support, but not to make an escape to go into a residence or some type of private property.
I believe he's actually in front of that. He is at the fence, and he does give it a push.
Yes, I agree. He is at the fence.
Yeah.
But Your Honor, I do agree with you that the second basis for the district court's conclusion here that there was probable cause being these furtive or evasive movements, I think is not entirely supported by the video. I don't think the brief movements that Mr. Alexander made when several police officers are approaching his group would amount to the type of evasive or furtive movements that would cause concern that someone's trying to escape or someone is presently breaking the law.
So do you think that we, as an appellate court, should make our own conclusion about how evasive or not this may have been, or do we owe some deference to the district court?
So you owe deference to the district court's finding of fact, and I think his determination of probable cause gets reviewed de novo. I think because there are videos in evidence here and that have been made part of the record on appeal, that Your Honors definitely should review that evidence and make a determination as to whether the district court's findings of fact regarding that were clearly erroneous. I submit that they were. I don't think the limited and small movements that Mr. Alexander made on the night in question would amount to something that can be deemed evasive.
On the video, at least once, if not twice, he does sort of pat at his waist. I was trying to figure out why he pulled his shirt up when they arrived, his polo shirt.
Your Honor, when you refer to he, are you referring to Mr. Alexander?
Yes, he's the one that pulled, he pulled his polo shirt up, and I wondered what that was.
I don't think when he pulls his shirt up he's revealing the presence of a firearm. I think the firearm was always secreted up until the point that he's subjected to search.
No, you're right. I didn't see the firearm at that point, but I did see it, of course, go into his waistband.
But you can see the few seconds of open carry, momentary open carry during the transfer of the firearm.
Mm-hmm.
That's what's
absolutely
not
concede
debatable
that
here.
the firearm is out in the open from the time that the individual who passed it to Mr. Alexander has it in his hand. Mr. Alexander receives it, puts it into his waistband.
So it's a technical violation of the statute against open carry.
Perhaps I would submit that a statute that mandates concealed carry or prohibits open carry would give an individual who has just taken possession of the firearm a reasonable amount of time to conceal that firearm.
Is there any Illinois case that has so held?
Judge, in preparation for this brief, I did not find a case, but I'm happy to look into it and file a memorandum if Your Honor would like me to.
I mean, it's up to Chief Judge Sykes, but I think we can do our research.
Thank you.
Thank you.
Mr. Mauer.
Good morning, Your Honors, and may it please the court. The district court properly denied the defendant's motion to suppress. The court correctly found that by the time officers conducted any Fourth Amendment seizure of the defendant, the officers knew at least 3 facts directly related to this defendant that indicated he was involved in armed criminal activity. 1, the defendant, in the district court's words, surreptitiously received a gun from another individual in a hand-to-hand exchange on a crowded public sidewalk. 2,
Before you go into 2, could we stop at 1, please? Mr. Maurer, is there any minimum period of time that an individual must openly handle or carry a firearm in order to violate the statute? It was a matter of just a few seconds in this case. And my rather limited research gave me United States versus Span, but 11th Circuit, that was 10 to 15 seconds of carrying, or rather, carrying an uncased rifle from a dwelling to a car. And then there's one, Morris is the Southern District of Illinois, which isn't binding on us, of course. But so other than that, have you found any Illinois cases?
No, Your Honor. The government is unaware of any cases that define a hard and fast durational requirement one way or the other. The district court did find that Mr. Alexander held the gun exposed for 5 seconds, is what the district court found. And the district court also noted that it also was unaware of any durational requirement for the Illinois statute.
So let me tell you what bothers me about this whole thing, and it's a much bigger question that's not really argued here. But it seems that the police are operating on the assumption that if you have a gun, you've done something wrong. And this is not the world we are living in now. People are entitled to have their concealed carries if they've got the proper FOID and they've got, and we don't just look out on the street and assume everybody's a felon. Even let's assume that's a perfectly okay restriction. So what is it about this, other than this momentary glimpse of something that turned out to be a gun, that would make anybody think somebody was doing something wrong? Two legitimate people could exchange a gun, one from the other.
Yes, Your Honor. I think the issues would be that this exchange is occurring on a public sidewalk. At the time that this particular exchange occurred,
Why is that suspicious, though? I mean, if we live in a world where gun ownership is understood to be one of the rights that people have, and they can carry them around outside their home as well as in their home, and you're familiar, I'm sure, with this huge line of cases. Why are those things that would allow the police even to wind up with tarry reasonable suspicion, much less probable cause?
Because again, Your Honor, I do think it matters that this exchange is occurring amongst a large crowd on a public sidewalk. We have the additional fact here of the shot spotter alerts that go off prior to the officers responding to the scene, which was the impetus for
All right, well, that might be a different factor that I can...
Yes, Your Honor. So there were multiple shots fired in the vicinity, which is what caused the officers to review this police observational device camera in the first place, and then happened to observe this exchange between another individual and the defendant. Returning to my prior points, again, the defendant exposed the gun that he was handed out in the open and amongst that crowd before secreting it in his waistband. And then, as the district court properly found, he tried to furtively evade officers who responded to the scene. All of those actions were observed by officers who were watching that police observational device camera, and collectively those facts provided probable cause to believe that the defendant's gun possession was unlawful. As the district court properly found, Illinois law prohibits the carrying or possessing of firearms on public streets. And although the law exempts possessions that comply with the Firearm Concealed Carry Act, under that act, the possessor must keep his gun completely or mostly concealed from view. And during that 5 seconds that the defendant openly exposed his gun on this sidewalk, it was not concealed at all.
But what does the mostly part mean? Does it mean that you can be walking along and have part of it poking out of your waistband, or does it mean you can have a 5-second period of time that you're just transferring it from one person to another?
The statute does not further define the term mostly. Here, we don't have a scenario where we have a portion of the gun exposed, maybe the magazine or the butt of the gun. It's the entirety of the gun that is exposed by the defendant for that entire 5-second period. So we don't have any concealment whatsoever, let alone concealment that may or may not be mostly concealed. Another reason supporting the officer's actions was what the district court described as the defendant's plain attempt to avoid the responding officers. And specifically, the district court found that the defendant took note of the officer's arrival, ducked behind another man standing against a nearby fence, and then quickly tried to move to the other side of that fence once the police arrived at the scene.
That's all good for a Terry stop, but we're,
Right.
I think, operating under a probable cause standard here. I mean, I know you've argued this in the alternative. But,
Yes, Your Honor. The district court did apply a probable cause standard here. I do think the evasive maneuvers contribute to a probable cause assessment. Certainly, them in and of themselves don't do as much to provide you probable cause as they might under a reasonable suspicion standard. But here, when you pair those evasive behaviors with the open gun possession, which the district court found both of those facts to be present here.
what crime does the furtive movement exhibited by the defendant point to?
It could be the open gun possession that he knew that he had openly possessed his gun on a public sidewalk. Could be for another crime, such as being a felon in possession. And again, the district court ultimately did not rely upon any of those suspicions. It relied on a probable cause assessment of an arrest for exposing this gun on a public sidewalk. But the furtive evasive behavior could drive to any number of illegal activity, to include the illegal activity that the district court found here.
I must tell you that if that were the only issue, the furtive whatever, I would not be with you on that. The man took one, at the most, maybe 2 steps to the left, and then slightly, he didn't use the full force of his body against that fence. He just kind of went against the fence. I am not, as I said, particularly impressed by those movements.
Yes, Your Honor. And in a world where all the officers were relying upon were the evasive behaviors by the defendant, and they just happened upon this scene without any knowledge of any firearms whatsoever, the government very likely would agree with you under that hypothetical. But here, where they have the shot spotter alerts, the hand-to-hand gun exchange, the exposure of the firearm, the evasive behavior is just an added layer building upon that probable cause analysis that had been ongoing before they arrived at the scene. So accordingly, pending any further questions from the court, the government would respectfully request that you affirm the district court's judgment.
Thank you.
Thank you.
Mr. Stanton.
Counsel mentioned a couple times these spot shotter alerts, and I don't believe the district court relied on that in his decision. I would point out that the shot spotter alerts were not on the 4400 block of West Congress where Mr. Alexander was standing with that group of people, but they were on other blocks in that West Garfield neighborhood. So to add that into the analysis here, I think is a little misleading, because the registered shots that the Chicago Police Department had indicated from those machines or from those devices were not where Mr. Alexander was. I do think that the Chicago police were operating on the assumption here that someone handing someone else a gun in that neighborhood, there must be doing something wrong or committing an illegal act. I don't think.
Well, that may be true as a subjective matter, but this is an objective standard.
Absolutely.
And, an open transfer of a firearm on the public streets is unlawful under Illinois law. So even if the violation is hyper-technical, it's still a violation.
Seconds long, I think, would be a reasonable transfer.
And maybe a prosecutor wouldn't file charges on that. There's bigger fish to fry in Cook County, but, and maybe that wasn't the intent of the open carry prohibition, or the purpose of it. It was aimed at more serious conduct than just transferring a gun one person to the other. But it is a technical violation.
If there's no other questions, thank you for your time.
All right, thank you. Our thanks to both counsel. The case is taken under advisement. We'll move to our second case this morning, United States against Freyrmuth. All right, Mr. Masiolik.
Morning, Your Honors. May it please the Court. I'm Mark Michalik with Murphy Desmond SC, representing appellant Corey Freyrmuth. The only issue we raised in this appeal, Your Honors, is the application of minor role at Guideline Section 3B 1.2 sub B. With the changes to the guideline in 2015, the essence of the district court's decision to apply or not apply the minor role is to compare the individual defendant's role to the roles of the average members of the criminal activity, in this case, a drug conspiracy. Anybody could do what Corey Freyrmuth did. He did what he was told. The average members of the conspiracy, by contrast, and nobody disputes that the average members of the conspiracy were regional methamphetamine dealers in Wisconsin who were regularly distributing pound levels of methamphetamine.
Mr. Maciolek,
Yes.
are you arguing that he had more than one job here? He was involved in multiple significant parts of the conspiracy. Now, it's true, of course, that he seems to have been operating as his brother's lieutenant, but he seems to have shouldered a significant amount of responsibility. He stored meth, he maintained the inventory, he delivered the meth to dealers, he collected, laundered the sales proceeds. There's no question that he wasn't, the leader, but he wasn't simply the low level I don't like that word mule, but I'll use it. Was he?
I agree, Your Honor. He was not, the typical drug mule, someone who may be recruited just to make one trip at high risk, low reward, someone that DTO finds to be disposable. On the other hand, the comparison is between the average members of the conspiracy, which were pound level drug dealers who had their own networks, their own customers, had discretion, had really had the sky's the limit. They could build their own business. Corey did what he was told, and while he did,
why is that? Excuse me. Why is that so dispositive? The judge, Chief Judge Peterson, notes again this multifaceted role. He's a jack of all trades. He's doing all different kinds of things. Now, granted, that's different in type from being a specialist about distribution or a specialist about transportation or other things, but it's the very versatility that I think bothers the judge, and he's inevitably comparing apples and oranges, right? But he's saying this guy is so helpful to the conspiracy, I guess I'll say. He's playing a particular role that does not make him comparatively less important than anyone else. It's even though the roles are different.
So, Your Honor, I think that the distinction is essentially that, as I was thinking about it yesterday, I came up with the comparison or the metaphor of a server working in a restaurant. That person is involved in almost every aspect of operating a restaurant, serving food, food safety considerations, security of the establishment, accounting, reporting for tips, collecting money. But you wouldn't say that and that sort of person is integral to the operation, which I think is really what Judge Peterson found, is that he's important, but he's also someone who's easily replaceable. And the amendment to the guidelines and the commentary tell us that all the decisions that come out of this court and several of the government cites, it really doesn't cite any decisions that actually interpret the rule as written now. It's all before then that it relies on. Tell us that just because somebody is integral, or the conspiracy wouldn't have been the same without them, that doesn't disqualify them from having a minor role reduction. So,
but it is comparative, and I hate to say it, it's actually quite regrettable, but I mean, all of these distributors turn out to be pretty replaceable too. You see one goes to prison and somebody else pops up, and there's a scope that I think the judge, and our review is deferential. That's another point I'm trying to keep in mind. So to be able to say that he is, that anybody who looks at this would have to realize that he is less important to this conspiracy than the average member, that's a stretch.
And that quibble again a little bit, Your Honor, with the less important or less integral is again sort of the old way of pre-amendment of looking at these things. And really it's the comparison between the average members of this conspiracy and this particular defendant. And the district court, in its findings, recognized Corey really had no discretion. He did what he was told. He handled, there's large quantities of methamphetamine here, but that's because of, nothing to do with Corey. If this had been a conspiracy involving, distribution of 5 grams of methamphetamine at a time, Corey's, the skills or whatever he brings to it don't change at all. There's nothing about what he does, it's just bigger amounts. All he does is
why does taking instructions mean that you have a minor role? It seems to me that those are two different considerations. We're not talking about leader, organizer, manager, supervisor. There, I certainly would see the importance of how much discretion you had, but minor roles at the other end.
I think it is because, it's not, I wouldn't argue that just because somebody is given some instructions, that means they always have a minor role. But in this case, all Corey did was follow directions. He didn't do anything independently. He didn't even talk to the regional distributors. It was, the chain of communication was they spoke directly with Levi Bagney. They made decisions about, what to distribute, who to distribute it to, how much it was going to be, whether Levi Bagney was going to provide money to help the regional distributors with court cases that cropped up, and Corey wasn't part of any of that. So it's not that the fact that he received instructions, it's that all he did was follow instructions. And I agree, Your Honor, that taking people off the street through drug prosecutions has been ineffective in reducing the number of drug dealers. But nevertheless, these people, Pelkey, White, the other regional distributors, have risen to a level that they have skills, and they have developed these networks, and they have almost, it's unfortunate really, because they have the same sort of skill set as small business people, deciding who to trust, who not to trust, how to manage money. Corey did none of that. All he did was take things where Levi told him to take them, pick things up when Levi told him to pick them up, and send the money back in a fashion that that Levi told him to do. So it's true, that's money laundering, and that makes it sound like something much bigger than it is. Just like if we say, oh, this person's a drug trafficker, that sort of sounds like, oh, they're driving a big fancy car, they're moving lots of weight. But drug trafficker can also mean someone who's drug dependent, gets money pooled, and distributes a little bit to survive. Those, just those categories I think are not really helpful. So I see I'm into my rebuttal time, so I'll answer any questions that might come up right now. Otherwise,
I do have a question about harmless error. I don't see how this affected Judge Peterson's sentence at all, the denial of your minor role adjustment. The sentence here was far below even the lower guidelines range that would have that the minor role adjustment would have produced.
I agree it was. I guess Yeah, and then there are certainly judges like Judge Edelman in the Eastern District who will explicitly say, I really carefully considered this guideline issue, I'm overruling it, but even if I had gone the other way, it wouldn't have affected me for these reasons. I don't think Judge Peterson gets into that explicitly at all, and he, I think more than anything recognizes that Corey's role in the conspiracy is a mitigating factor, which I have trouble squaring with his denying the minor role adjustment, if that is, in fact, one of the factors he relied on.
The way to square it is to conclude that the guidelines range had no influence whatsoever on his decision, which is pretty clear from this transcript.
And that may very well be the court's impression. I would just stand on the court's precedent where there are numerous decisions that say without an explicit disclaimer that the court's not relying on the guidelines or that the objection wouldn't have mattered, that this court's been hesitant to find harmless error.
Fair enough. All right. Mr. Wagner.
Yeah.
Good morning. May it please the court, Aaron Wagner representing the United States. The government is asking the court to affirm the judgment and conviction order of the district court here. The district court's decision to deny the minor role reduction was not clearly erroneous. It's noteworthy that this court has previously stated it will rarely reverse a district court's denial of a defendant's request for a minor role reduction. To succeed in obtaining a minor role reduction, the defendant was required to show that he was substantially less culpable than the average participant in the conspiracy. Here,
Do you think, forgive me, do you think it matters whether Mr. Freyrmuth exercise any degree of discretion or independence in carrying out his brother's instructions, so long as the tasks he carried out in furtherance of the conspiracy were more than minor?
I don't think that it does matter. I think if he followed those directions explicitly with no discretion, I think this court should still look at the totality of the circumstances regarding all the different tasks that he played and how important those tasks were. But I would note here, and Judge Peterson noted the same, that Corey Freyrmuth was in Wisconsin, Levi Bagney was in Arizona. So this was not a case where somebody was sitting right next to him telling him what to do. He did have some discretion. He did have some independence. He wasn't directly supervised hardly ever in the tasks that he was carrying out. So I think that is a factor that this court should consider, and Judge Peterson considered too, in deciding whether a minor role was appropriate. So the district court here did have an ample factual record to find that the defendant failed to show that he was substantially less culpable than the average participant. The district court reasonably concluded that this defendant was a full participant and that he played a multifaceted role. As this court has already noted, he was responsible for the transportation and storage of methamphetamine, the delivery of methamphetamine. He also collected money, and then he laundered that money through multiple bank accounts back to Bagney in Arizona. Even if the district court...
I'm sorry, I'm interrupting you again, but do you think that we should factor in at all the fact that Mr. Bagney seemed to think Mr. Freyrmuth didn't do his job very well, wasn't terribly good at it or bright or whatever? We seem to be complaining about him quite a bit.
I think that's something the court could consider, but even with that said, the defendant here had all of these roles for a long period of time. This is a conspiracy that went on for over a year and a half. And so all of these roles that we're talking about, he did over and over and over again. So if Mr. Bagney was really that unsatisfied with the defendant's work in this organization, he could have tried to replace him. Now, there was an issue brought up earlier about replaceability and whether that is something the court should consider here. I think the analogy that was made with a server in a restaurant is not a particularly good one. Here you have the defendant who is Bagney's half-brother, and he trusts him. And I think that was a huge part of what Judge Peterson decided in looking at the totality of the circumstances, was the level of trust that Bagney had in the defendant. This was his half-brother. And there was nobody else in a similar position in Wisconsin who could effectively run the organization in Wisconsin while getting directions from Arizona. This was the only defendant who was in that situation. And so that level of trust, I think, is a huge factor for this court to consider in deciding whether or not a mitigating rule was appropriate.
How important, if at all, is the fact that Mr. Freyrmuth seems to be kind of at the mid-level of the conspiracy? He's not the supplier. He's not out there in the street distributing things. He's in some middle management coordinating role. Are we supposed to think about this minor role adjustment in those kinds of hierarchical terms, or is it just each case is its own picture?
I really think each case has to be its own picture. I don't know if I necessarily agree that he was middle management here. There was really nobody else who had a similar role to what he had. And it goes back to, I guess, my original point that he was unique in that aspect. And what is required in a drug trafficking organization to succeed properly is quite a bit. And I think this case shows all the different things that need to be done. So, for example, here, the defendant was receiving packages containing multiple pounds of methamphetamine in the mail. He was then going to a storage unit, and he was storing the meth. He was a leaseholder on that storage unit. When Mr. Bagney would call him to make a delivery, he would have to go to the storage unit, he'd have to pick it up, he'd go deliver it to the customer, and at the same time, take the proceeds, sometimes over $20,000 at a time, and then he'd go to the bank, and he'd do what Levi Bagney's told him to do several times, which was make cashier checks to certain people, deposit it into certain accounts. So it really was this multifaceted role that I think put him in a very unique situation. And I don't think it's necessarily true that he was a middle manager. I think it was something beyond that, that his role was in this organization. And once again, it's just that really high level of trust that Bagney has in him, I think sets him apart from certainly a minor role player, but I think also an average participant even in this particular conspiracy. I also wanted to mention that I think this case is very similar to the Gallardo case and the Gonzalez cases that I cited in the government's brief. In both of those cases, this court found that the district court did not clearly err in denying the minor role reduction. I think it's also noteworthy that there was no attempt to distinguish those cases in the appellant's reply brief. In summary, I think the defendant viewed his role in this offense one particular way, and the district court and the government saw his role much differently, and that conclusion was not legal error by the district court. So unless the court has further questions, I would end by asking you to affirm the judgment and conviction of the district court in this case.
Would you address the harmless error point?
Yes, I agree with you, Judge Sykes, that I think he would have reached the exact same sentence regardless of this guideline issue. And he basically, Judge Peterson basically said as much in the transcript when he said he was taking a holistic view of the sentence and applying 3553A factors in addition to the guidelines. But
we don't have the kind of explicit statement on this record by the judge saying, even if I was wrong on the guidelines calculation, this would be my sentence,
I agree.
which is sort of a safe harbor, for lack of a better way to put it, on a harmless error analysis.
I think Judge Peterson got right to the edge of that and sort of stopped without explicitly saying it. I think it's certainly clear, as you noted from the transcript, that that was what his thinking was, but he did not explicitly
What's
say
the
that.
law on that point? Is that's certainly sufficient for harmless error if a judge says explicitly that this would be my sentence, even if I'm wrong on the guidelines range. Is it necessary?
I don't believe it's ever been said that it's necessary. I think this court could certainly view this as a harmless error type case. But with that said...
Is that sound as a legal rule? I mean, if we said that in this case, that would be making some law, right?
I think that is correct. And the government is completely comfortable moving forward here with clear error and that standard, which is obviously very deferential to the district court as well.
Can you address the question? Is that sound as a legal rule, that an explicit statement is sufficient, but
I think
it's
that,
not necessary? Is that a sound legal rule for harmless error analysis?
I don't know if it is, Your Honor. So,
Well, you have to also consider, would such a rule be consistent with the Supreme Court's insistence that we have to start in anchor cases in the guidelines?
right. No, that makes sense. Total sense. And like I said, I think he could have said it explicitly. He didn't. I know in the end we talked about the fact that this court could view it as a harmless error case, but at this point, I mean, the government's completely comfortable just saying this should be viewed under clear error and leaving it at that. Thank you.
Mr. Maciolek?
Thank you, Your Honors. I have barely a few moments, but I did want to address really
We covered
quickly.
a lot of ground. You can
Yeah.
have some extra time.
Okay, well, thank you. The idea that Bagney trusted Corey, of course he did. He let him, have lots of methamphetamine that he would, take out to places at Bagney's direction, bring back money that, he could have gotten away with or whatever, right? And I also agree that Bagney's not, physically present, hovering over him, but he's definitely supervising him, everything he's doing. Take 2 pounds to this guy, 1/2 pound in each hand, that's how much you need. Take this much to this bank, this much to another bank. Wake up, brother. It's time to go to the bank to, basically further the money laundering. He is very carefully supervised. He's not out there doing anything on his own. Fundamentally, usually, right, the robust review of sentences we have in federal court compared to state court is really a fundamental difference between the two systems. And this guideline kind of strikes me as being much more nebulous and malleable than almost any of the other ones that I can think of, where if it really comes down to just, well, the totality of the circumstances and however the district court wants to weigh this is fine, I guess maybe that's the rule. But normally that's not the rule, and we're able to essentially solve the guidelines as a problem, right? There's usually an answer. Not like, for example, Wisconsin's foray into guidelines where they basically published a list of factors and it's like, it could be mitigating, could be aggravating, it's up to you, right? Which did nothing for advancing various purposes of sentencing. We'll list those off. So,
Counsel knows he's arguing in front of one judge who's from Wisconsin.
Your Honor, yes.
Just for the students in the audience. I know there's some students in the audience who helped design that system that he's describing.
And I'm not saying it wasn't
I
helpful.
get the difference.
It's just different. And to the extent that the guidelines should continue to be employed, as the Supreme Court has told us they must be, I think that this court establishing more standards to aid the practitioners and the district courts in applying the minor role and even the mitigate or the minimal role would be very helpful. So here, the final thing I have to say is Judge Peterson found facts that support the minor role and then declined to apply it. And I think fundamentally that should be error, even under a deferential standard. Thank you.
All right. Thank you very much. Our thanks to both counsel. The case is taken under advisement. We'll move to our next case this morning, Sandra Diaz versus the Commissioner of Social Security. And Mr. Duncan, if you would just hold up 1 minute till we can be sure we have Ms. Kuschek on Zoom. And it looks like she's there. Can you hear me, counsel?
Yes, I can hear you.
All right, great. Thank you. Then we can begin.
Thank you.
Mr. Duncan.
Good morning, Your Honors. May it please the Court. Dana Duncan on behalf of Sandra Renee Diaz. The history of this case would probably take up most of my allotted time, but the key issue in this is the only issue before the Court, which is whether the administrative law judge, Judge Parker, and while I usually use a generic ALJ, considering she's the fourth ALJ to be involved in this case, I will refer to her by name. In her decision of March 9th, 2021, whether she adequately weighed the opinion of Dr. Manos. Now, this case falls under the old rule. The new medical opinion rule was established effective March 27th of 2017. So that's how old this thing is. This goes back to the original rule, which was step one was if it was a treating physician controlling weight. And then the second part of this, which is under, because this is an SSI case, 20 CFR 416.927 sub C sub 1, which is significant weight to be afforded to an examining physician. Dr. Manos found two significant things. One, she was intolerant of routine work stress, and two, she had marked interactions with supervisors and coworkers. Ms. Diaz testified at hearing about stress and her difficulty in dealing with coworkers, having situations where she indicated She would probably walk off the job if criticized by a supervisor. She also had a diagnosis of borderline personality disorder, which is by itself a condition that seems to trigger such responses that are not normally acceptable within a work environment.
So Mr. Duncan, let me ask you this. We've narrowed this case down, if it's possible to say that, to this closed period, because
Correct.
she is getting her benefits after a certain date. And I understood the administrative law judge to be weighing Dr. Manos's opinions, which are pretty serious opinions, as against her responsiveness to treatment when she was able to stay on treatment at the time.
Yes.
And I'm concerned about how much we're supposed to reweigh this. Your basic point seems to be one that I'm actually fairly sympathetic to, which is when you're dealing with mental illness, the inputs that the trained psychologist or the trained whoever it is are going to be using are her accounts of what
Correct.
she's experiencing. So it's a little hard to criticize the subjective inputs, but it is possible to say, is she really this limited if she's able to respond during that closed period of time that we're talking about to treatment?
Well, this is a fundamental point, and this is one that Magistrate Judge Duffin said in his first decision, which is, yes, you've established that she has improvement in her bipolar, but you've not established that she still would not have significant problems dealing with routine work stress. The two do not go hand in hand. He implied that you really should have gotten a medical opinion on that fact. I mean, after all, Dr. Manos was brought into this case because of a lack of any significant mental records, and that's why he was brought in.
Right, and he only examines her once, though, right? He is an examining physician, but only once. Yeah.
Correct. And what I can do, and I would, when I was reviewing in preparation today, I forgot to look at a thing called the Green Book, which Social Security publishes, which is the instructive manual for consultative examiners. And I will provide the citation to that as a supplemental after oral argument. But he complied with the Green Book, which says you are basing your decision when we order one, it's because there's a lack of evidence. So then turning around and saying, well, it's not supported because there isn't enough evidence in the file to support the opinion is begging the question, because that's why the judge or why the consultative exam was ordered. The second part of that is it specifically outlines that you're supposed to have a mental status examination and observations, which are the key components of your opinion. Okay, so that's what he did. And then to say that it's just subjective statements does not, again, provide any justifiable situation.
Forgive me, Mr. Duncan.
Yes, Judge.
How do we deal with this situation? In October of 2010, Ms. Diaz told Dr. Manos that she had stopped treatment and run out of medications in the spring because she had lost health insurance and her psychiatric symptoms were back and she was depressed. But in September and November of that year, she told her primary care physician that her bipolar disorder was well controlled.
Correct.
How do we deal with that?
It's very simple, Your Honor. What we have here are multiple medical conditions. We have nothing in the record that says any medication she was taking could have dealt with her borderline personality disorder, which is part of the whole basis and a key portion of why she cannot deal with work stress and why she has difficulty interacting with coworkers and supervisors. And that point right there, which is why in my brief in support, I outlined in detail the findings associated with the DSM-5 as to what a personality disorder is, why that was so important. I'm not a medical doctor, nor am I a psychologist or a psychiatrist, and I know the court probably is not either. That's the problem we have in this case. And when we've had this going on for this long and we've already ordered consultative examinations, we had an ME who never was brought in by Judge Messina to testify, but never asked to opine on specifics about stress or interaction. I mean, it just begs, why wasn't this addressed? And the only reason I can come up with is because the ALJs didn't want the answer. Because, you know, we're talking about 4 different ALJs and I believe 5 decisions. And they wanted to uphold what was going on, which is a denial.
Now, Mr. Duncan, why couldn't the ALJ reasonably infer that if she's able to cooperate with her medical providers, she can also cooperate with prospective coworkers and supervisors?
Because in a treatment situation, it's a different situation completely than when you're in a work environment dealing with supervisors who are criticizing you. You're not, or correcting you. I cited the Morales decision from the Third Circuit where they specifically said that treatment is much different than being in a work environment. This court has said on repeated times that daily activities have to be taken into account versus outside versus inside a work environment. And I think that's the biggest problem with this, is that we just don't have enough here to say that her treatment or being cooperative with treatment providers was going to show that she had ability to deal with supervisors. I mean, it's unrefuted testimony that she said if she was criticized, she would walk off the job. That's in the area of record 1982 to 86, where she testifies to those difficulties. So that's the problem we have. I mean, in and of itself, the judge provided reasons, okay? I dispute as to the validity of some of those reasons, but there are problems with those reasons. And then take it into account that you're supposed to give greater weight to a source who is actually examining the claimant. There's just not enough evidence here to justify the discounting of Dr. Manos on this record. So I am out of time, and I will rest this argument and my briefs.
Thank you. Ms., is it Kuschek?
Yes.
Okay, you may proceed.
Morning. May it please the court, my name is Jane Kuzik, and I represent the acting commissioner of the Social Security Administration. Before diving into my argument, I'd like to address just a couple points that Mr. Duncan made. First, Ms. Diaz does not have a diagnosis of borderline personality disorder. I think Dr. Manos and maybe one other provider suggested it's possible she had it, but it was never a diagnosed impairment. And if it's not a medically determinable impairment, ALJs cannot consider it.
So
but
what's the
regardless,
line you're drawing there between, I mean, a number of people do talk about borderline personality disorder. So you're looking for a piece of paper or a statement. I have decided, Ms. Diaz has borderline personality disorder, period. I mean, it's
yes.
pretty clear in the record that they think that's a problem.
It is suspected, it's not really relevant what her diagnoses are, because as long as she has a medically determinable impairment that could cause her alleged symptoms, ALJs go on to consider the effect of those symptoms. So,
and so
regardless
the
of
fact
her
that
diagnosis,
she's displaying lots of symptoms of borderline personality disorder at the stage you're talking about would be enough. The ALJ would need to take that into account.
the symptoms, yes, and so the ALJ would assess what the record says about how she's functioning, regardless of what's causing the symptoms. And another point I just like to address that Mr. Duncan made about the medical expert in 2018. She did address Dr. Manos' opinion at page 992 of the record. She stated that she disagreed with Dr. Manos' opinion because it was based on subjective allegations that were not corroborated.
But you see, that's gobbledygook when it comes to a psychiatrist or a psychologist. I mean, Dr. Manos was a psychologist. First of all, he's reporting visible things: tearfulness, distress, irritability. I don't know how any psychologist is supposed to evaluate objectively whether someone's hearing voices. It seems to me that's a self-report inherently. You can't get into their head. And you have quite a bit of evidence about her daily activities, which are largely done by her daughter. I mean, there's a lot of external evidence that corroborates what this psychologist is seeing in this person. You wouldn't say that bipolar disorder is undiagnosable, would you?
No, she certainly has medically determinable mental impairments. That's not in dispute. The dispute is whether the ALJ reasonably evaluated Dr. Manos' opinion. And she did. She followed the regulations by reviewing all of the evidence, most of which Dr. Manos did not see. And she explained over 3.5 pages why she determined that the evidence in this case did not support his opinion, and some of it was inconsistent with his opinion.
Well, that's right. So we're evaluating that, but I mean, she does need to engage with what Dr. Manos thought the impairments were, and then it's the ALJ's job to say, okay, given this set of impairments, what can you do?
Yes, and she did. She evaluated the subjective allegations that Dr. Manos relied on. So she determined the opinion. Well, let me back up. Ms. Diaz's response or argument basically boils down to a demand that ALJs give blind deference to consultative examiners. However, that's not what the law says. The law places the burden.
It is a pretty extraordinary situation, isn't it, when an agency is seeking to discount the opinion of its own expert?
Consultative examiners are independent examiners who evaluate claimants at one time.
But the point is, but I think Judge Rovner's point is that they are not, for example, a treating physician who may have developed a long-term relationship with a patient who might want to be helping. They're just people who come in from the outside, solicited by the agency, and perform an examination and report back.
Yes, they issue an opinion, but the law requires ALJs to critically assess medical opinions and not just accept them blindly. And that's what the ALJ did here. She found the opinion was unsupported. Ms. Diaz argues it was supported because she relied on subjective allegations. And subjective allegations are certainly an important piece of evidence, but it's only one category of evidence that ALJs are tasked with considering. Just with just as with medical opinions, ALJs are tasked with critically assessing subjective allegations. Is it consistent with the record? And the ALJ reasonably concluded here that it was not. Dr. Manos rested his opinion on subjective allegations. However,
but what other allegations would support this diagnosis? I mean, it sounds to me like the commissioner is saying this is just not a basis for Social Security benefits, period. Let's stop talking about mental illness.
Well, no, the record thoroughly reviewed her mental illness. The ALJ noted that subjective allegations were not a reliable foundation for Dr. Manos' opinion in this case, because the subjective allegations she presented to Dr. Manos were inconsistent with the subjective allegations she gave to treating providers at the same time. In July 2010, she started treating with primary care provider Dr. Winter. Dr. Winter's notes indicate that Ms. Diaz was taking her medication, that her bipolar symptoms were controlled, and she saw Dr. Winter 7 times between July 2010 and January 2011. And at no point during that period did Miss Diaz ever report having any problems with mental health. And yet, in the middle of this period, when she was treating with Dr. Winters and not telling Dr. Winters about any of her symptoms, she came in and in October 2010 told Dr. Amano something very different. She said that her mental health symptoms were so bad that she was hardly functioning during the day, that she was sleeping, that she was spending her time staring out the window, that she was having thoughts of cutting herself. But the ALJ reasonably determined that if that was the case, if her subjective allegations were that bad, she would have at least told her treating provider about that, because her treating provider was the one in position who could help her, not Dr. Manos.
Does anybody ask her why she didn't? I mean, it seems to me, if I go see, a neurologist, I might not be discussing gynecological problems with the neurologist. People are seeking out care from the right specialist.
Yes, they had that discussion at several of her hearings. As she testified, the evidence was inconsistent with when she did or did not have her medications available. She told Dr. Manos that she had stopped taking medication in April 2010 because of a loss of insurance, and the ALJ acknowledged that. However, in July 2010, we have Dr. Winters' notes indicating she was still taking her medication at that point. And in January 2013, she testified that
Did he
she had
specify
taken
what medication and how much of it, or just taking medication?
She consistently told Dr. Ice, her treating psychiatrist from 2006 to 2010, that she did well on Lamictal, Guiodin, Seroquel, I think Wellbutrin. And most of the time, as long as she was taking that medication, she reported doing very well. And so we have this brief period where she wasn't.
But even then, she's having faint, these hallucinations, faint auditory hallucinations. It's an odd thing, but people seem to be able to get used to almost anything. But it's
And
still
she
someone who hears voices. Wow.
She reported that her hallucinations were controlled with medication. And later she testified that even when she stopped taking that medication, her hallucinations never returned. Even if we take at face value her subjective allegations that she presented to Dr. Manos, it only represents a very brief period of functioning. During this 10-year period at issue, the vast majority of the time she had insurance and access to mental health treatment. So this was a brief worsening that did not represent her typical functioning, and the ALJ understood that. I see I'm about out of time, so I will, if the court has no other questions, I will rest on my brief.
Thank you.
Thank you.
Mr. Duncan, you had used all your time, but I'll give you some extra time if you have something briefly to say in rebuttal.
Yes, thank you. I'll just make three very brief points. One is the situation is yes, she improved, but she also was not working and in control of her environment and activities. There's nothing to say that if she went back into the workforce, as I think even Dr. Manos had indicated in his opinion, that this was not likely to change. If we do not take such things into consideration, we're going to have people yo-yoing on and off benefits depending on whether they're forced to work or not. Second point that I would like to make is again, the ALJ relied on these mental status examinations that were done with her general practitioner, with her foot doctor, etc. They're not to the same level that a mental health expert would. And finally, one of the reasons that the ALJ cited was the lack of structured treatment, which implies inpatient. And apparently, and I've yet to find the regulation, but I have a lot of administrative law judges who imply that unless you're inpatient, your mental health is never serious enough to be on disability. That's just not the case. You do not need to be a danger to yourself or others in order to qualify. The question is whether it impacts your ability to work, and in this case it does.
Thank you very much. Our thanks to both counsel. The case is taken under advisement, and the court will take a brief 10-minute recess before calling the next case. Please be seated. All right. Our next case for argument this morning is United States versus Tommy Tran. Mr. Palmer.
Good morning, Your Honors, and may it please the Court. My name is Bob Palmer. I represent the appellant Tommy Tran in this case. The issue before this Court is whether a low-level supplier in a extensive multi-state conspiracy to distribute drugs qualifies as a organizer, leader, manager, or supervisor of the conspiracy. I have to admit, this is a difficult argument because there is no definition in the statutes of what is an organizer, leader, supervisor, or manager. Instead, the commentary note 4 sets forth 7 factors that distinguish between manager and supervisor and organizer and leader. That doesn't really help in determining what is a manager or a supervisor. What's even more difficult in this case is the fact that this is undisputedly a very extensive conspiracy. It covers areas between California and Illinois. There were several suppliers in the conspiracy. The pre-sentence report names numerous people involved in the conspiracy, yet the enhancement in this case is under section 3B1(1)(c), which is for a conspiracy of less than 5. And the question is, why would the government do this? And I submit that my interpretation of what the government has done in this case is they knew that trying to convince any court that the limited activities Tommy Tran had in this conspiracy would rise to the level of being an organizer or leader. And section 3B1(1)(c) in the background section of the statute says, in relatively small criminal enterprises that are not otherwise to be considered as extensive in scope or in planning or preparation, the distinction between organization and leadership and that of management or supervision is of less significance than in larger enterprises that tend to have clearly delineated divisions of responsibility. This is reflected in the inclusiveness of section 3B1(1)(c). So they couldn't prove he was any of these enhanced participants under a larger conspiracy, so they tried to go under a smaller conspiracy, which the evidence doesn't support in any way, and tries to mash them all together and say it's not of any significance. But it is of significance in this case because it was a 2-level enhancement of
Which is the lowest number of levels in that guideline. I mean, if you qualify for the other parts, it's more.
Correct. Yes, Your Honor.
So, I mean, the government does argue that he is engaged in significant activities, some decision-making authority, he's recruiting some accomplices, he's earning significant money, plans and organizes these shipments. I mean, that's the end of the conspiracy where he's operating.
Yes, Your Honor, and be honest with you, I was surprised at the arguments that the government made. For example, they argue in their brief that Mr. Tran's attorney conceded that he recruited that Mr. Tran recruited accomplices. That's not true. There's nothing in the record about him recruiting.
I'm sorry, because on page 23 of the sentencing transcript, it did appear, I thought, that counsel conceded that although Tran didn't recruit others to sell the drugs, he did recruit others to distribute the drugs or put them in the mail. Am I off?
No, Your Honor, that's correct. The situation was simply that Mr. Davis, who took over leadership of the criminal enterprise in 2016, I believe, he would go to or contact Tran, tell him what drugs that he needed. Tran would gather the drugs with the 3 people identified that they say he recruited. They would gather the drugs, send them to Davis. Davis would send the money back, and that was it. It was nothing that Tran had any control over as far as what drugs were requested, what the payments were made.
Was anything other than Tran keeping a ledger of payments for the conspiracy?
Your Honor, there's no evidence of that. There is evidence that Mr. Tran had the notebook that listed the transactions, but that has nothing to do with actual control or leadership or recruiting of any of the people involved. If I could get back to my point about the government saying that Mr. Page conceded that Mr. Tran recruited people, it's not in the record. In the addendum to the pre-sentence report, Mr. Page represented on behalf of Mr. Tran that there was no recruitment. In the sentencing transcript, page 8 of the sentencing transcript through, I believe it's page 11 of the sentencing transcript, Mr. Page, who represented Mr. Tran, specifically says there was no recruitment. I believe his exact words were, "Let me say it, there was no recruitment." And then the government's attorney gets up and on the very next page says, Mr. Page concedes there was recruitment. Okay, where did that come from? And then it translates into the brief somehow. There is no evidence of recruitment. I feel a bit like Justice Stewart many years ago saying, I don't know what obscenity is, or I can't define obscenity, but I know it when I see it. And I feel that way about this case. I don't know the definitions of organizer, leader, manager, or supervisor, but I know it when I see it. And more importantly, I know it when it's not there. Our reply brief, which I must give credit to my law student because he did the reply brief, picks apart the government's argument point by point with the references to the record for each point. Obviously, it's far too extensive to go into all the details here, but I'd like to give you a couple of examples. At one point, the government cites a letter from Kelvin Hang to Judge Myerscough, and the government says, it quotes, "He has always taken care of me." I don't know if they're using that as recruitment or as some kind of leader overhang or what, but that's only part of the sentence.
No, you furnished the full quote in the reply.
Correct.
Which
That's just
puts a
an
different
example of how
cast,
things
yeah.
are parsed to make it appear something that it's not. Pardon me? So I'll hold off on the other quotes because I would like to save a few seconds for rebuttal, but unless the court has questions,
That's fine, thank you.
thank you.
Ms. Seeberger.
May it please the court, counsel. My name is Sarah Seeberger, and I represent the government in this matter. Organizers, leaders, managers, and supervisors, they tell people what to do, they tell people when to do it, they tell people how to do it, and then they decide if it's done right. Tommy Tran planned drug shipments and payments, coordinated drug amounts and sales price, determined who would ship drugs and receive payments. And yes, he had 3 subordinates who he knew, they were his people, that he used to help him with that process. Tommy Tran and Mr. Davis worked together to lead their drug conspiracy to profit. The defendant...
You've asserted that he recruited, controlled, exercised decision-making authority over the 3 California subordinates. And of course, Mr. Tran asserts that the government has overstated the record on these points. What in the record supports each of these assertions? For instance, what's the best evidence of recruitment? Where will I find page sites for the best evidence of recruitment, of control, of decision-making authority? Where will we find the page sites for these?
Yes, Your Honor. If I could start first by sort of following up on your earlier question of opposing counsel concerning the record at the sentencing hearing, I'd first direct the court to page 9 of the sentencing hearing transcript, in which Mr. Page says, "We concede that he did have individuals pick up payments from time to time." And then Your Honor pointed out page 23, later on, "I understand that he recruited them to distribute or put them in the mail, but not to the extent of the network as Mr. Davis had." I would also, just as it relates to this, direct the court to a number of paragraphs in the PSR. One in particular that I think stands out in terms of control and sort of who's running things is paragraph 67. There's a conversation between Tran and Mr. Davis in which Mr. Davis talks about setting up the purchases, arranging a money shipment, and it's pretty clear that Mr. Davis has no real idea who these 3 people are who are then receiving money, which I think lends itself to a very solid inference that Mr. Tran is in charge. I would also note that paragraph 29 identifies Ms. Quach and Mr. Hang as merely couriers. There is another paragraph, I believe it's 38, that talks about collecting money, and Mr. Tran goes with Mr. Hang to collect his particular payment. There's also in the PSR language concerning the fact that Mr. Davis explains in paragraph 47 and then into 48 that Mr. Tran is his partner, which also lends itself to the inference that the other 3 couriers report then to Mr. Tran. In paragraph 70 of the PSR, it reports Mr. Hunn's, I believe, car at Mr. Tran's house. Paragraph 68, Mr. Tran and Mr. Davis talk about new lines of supply. These aren't conversations that are occurring with the 3 subordinates. And what I think is clear from looking at the PSR, which I will note uses language like Mr. Tran used the 3. He directed the 3. I recognize it doesn't specifically use the word recruited, but I think it is a reasonable inference that the court drew when you see that these people are not involved in this but for Mr. Tran. These are Mr. Tran's people. It was his girlfriend. It was his longtime friend, which is part of why the government, both in the district court and then in our brief, noted that letter. The letter's important for their relationship. Mr. Hang isn't involved in this, but for Mr. Tran's role in using him as sort of a cutoff man in collecting the money and helping him making those payments. I think that the point is that those are individuals who reported to Tran. He told them what to do. He got the information about where the payments would be, when to pick them up, and then delegated to his subordinates. And then, Judge, as you talked about, he was the one then keeping records of how much money came in. He was the one who had the ledger about how much money was coming in and what they were selling, which that I think also points to the fact that he is a leader in this, it relates to those 3 California subordinates. I think this also comes back to what we're looking at here is really a function in some ways of kind of common sense, right? Counsel talked about I know it when I see it, right? We know who a supervisor is. Sometimes a supervisor is, yes, a middle manager, and perhaps that's a more accurate label for Mr. Tran, but he certainly was a manager in this conspiracy in that he had 3 people underneath him who he told what to do, where to go, and when to do it.
What evidence supports the government's assertion that Mr. Tran directed anyone to mail a particular package? Does the government mean one of the intercepted Missouri packages, some other packages? Where in the record will we find that?
Your Honor, I recognize that the PSR focuses primarily on the receiving, and I apologize that I'm failing to point out the specific paragraph in the PSR at this point in time.
Sure.
But there is I feel pretty confident saying, and this is where I believe the PSR uses the word at his direction, that there is a paragraph which talks about how it was shipped by Tran or at Tran's direction.
Maybe 62 of the PSR?
Thank you so much, Your Honor. It is paragraph 62, which talks about agents knew a package was shipped at Tran's direction, either by Tran or one of his associates from California to the Monroe City location. Judge, I think the issue is that the defense seems to be saying there has to be more than what was presented. And the government's position here is really, this is enough. This is the lowest level, as the court pointed out. And I do not think this is some sort of scenario where the government selected that particular, to support that particular enhancement just because we felt it was so much of a stretch in and of itself. There is plenty of evidence in the record that Mr. Tran both shared some sort of role, both as it relates to the overall conspiracy in working as a partner with Mr. Davis, but more importantly and more clearly, that he was in charge of those 3 subordinates in California. There are cases, yes, that have different and other facts, but what these cases really tell us the salient point is that this comes down to a common sense approach in terms of did he have some authority and control over someone else? Did he have, relative to other people, that responsibility, role, and status? And the issue here is whether or not the court committed clear error in finding, as the government argued, that he did. And I think the record is, I think there is plenty of evidence here, and I don't believe that the court, there is some sort of clear conviction that a mistake has been made in this case, such that the district court should be overturned. So the government would ask the court to affirm the judgment. I would just like to make one last point. I think counsel, that I think is important here based on the reply brief. At no point in time has Mr. Tran challenged the facts in the PSR. There's some 50 paragraphs. That's not what the objection was. The objection is just the application. So the conclusions and facts in the PSR and elsewhere, those in fact are the facts that this court can rely on. And if there are no further questions, again, would ask the court to affirm.
Thank you.
Thank you.
Mr. Coleman.
Just briefly, Your Honors. Mr. Tran didn't challenge the facts because the facts don't support the finding that he is an organizer, leader, manager, or supervisor. If you, again, read the reply brief, look at the citations in the reply brief, match them up with the citations to the record in the government's brief, you will see, using a common sense approach, that Mr. Tran does not qualify for the 2-level enhancement. I'd also like to take my last 11 seconds, and Judge Rovner, if you don't believe I'm pandering to the court, I happy to see you back on the bench. It's been several years since I've argued in front of you. It's a pleasure to do so again.
I'm very, very happy to see you as well. I really am very happy.
Thank you, Your Honor.
Thank you. Our thanks to both counsel. The case is taken under advisement. And Mr. Palmer, thanks to your students as well. Or I think you had just one student on this case. Thanks to your student as well. All right, we'll move to the next case this morning. The United States against Davis. Robert Davis, different Davis. Last one was Sean. And Mr. Cohen, whenever you're ready.
Thank you, Your Honor.
Good morning. May it please the court, counsel for the government. Your Honor, this case, Mr. Davis's case, comes before the court after a conditional plea of guilty wherein Mr. Davis received a sentence of 90 months for possession with intent to distribute crack cocaine. However, as part of his guilty plea, he reserved the right to appeal an adverse ruling by the district court judge wherein Mr. Davis had challenged the seizure of the crack cocaine, some U.S. currency, and a small amount of methamphetamine that was seized by City of Marion detectives. This case goes back to December 2018, and at the time, Mr. Davis was driving a car of a friend of his, Travis Marshall, and Mr. Davis was going to pick up a gentleman by the name of Najim Kareem.
May I stop you, please,
Yes,
for
ma'am.
just a moment, because we really do know the facts here. But I just have been thinking about this so much because Mr. Davis argues that the officers didn't know that the windows were overly tinted because they hadn't, used a meter to assess the windows. But here's what I was wondering. Why aren't they allowed to pull a car over to check a tint with a meter if they have even if they have, let's say, a reasonable suspicion that the tint violates the law? Is there any evidence that a meter can be employed on a moving vehicle?
I don't believe so, Your Honor. I'm not aware of any way that can be done. I know the district, they did do a measurement during the suppression hearing. The district judge did do that, but that was done on a parked car. I don't think to my knowledge, I'm not 100% sure, to my knowledge, it cannot be done on a moving car.
Right.
I had
So
exactly the same concern Judge Rovner is expressing. The initial stop is going to be because the officer, given his experience and the rest, is going to see a car and think that looks as though it violates the state law standard, and that's when the meter comes out. I mean, you would never have enough to stop a car if you can't use a machine that measures the car's windows while it's in motion.
Yes, Your Honor. And one of the other things Mr. Davis did argue in his brief was he believes, or we believe, that even before that, there was no illegal activity occurring. Mr. Kareem was just waiting. He got off work, was waiting for a ride. The detectives did not. They were in a plain vehicle, unmarked car. They did not have reason to even initiate the pursuit or to follow him.
They didn't do anything to anyone, though, until they pull the car over for the tinted windows and obstructed brake light, right?
That's true. They
So-
followed him throughout Marion, but nonetheless, they were
I mean,
investigating or.
that's a tough standard that you're proposing. If the police see somebody standing around and they follow a car, but they never pull it over, they go about their business, you know, they haven't really injured that person.
That's true, Your Honor, but ultimately they did end up.
Well, so our focus is on the reason.
Yes, ma'am.
For the pullover.
And then one other thing I might mention, it's not really a misnomer, but this wasn't a typical stop where the sirens go off and they pull somebody to the side of the road. Mr. Davis and Mr. Kareem had actually arrived at their destination and were, and something was said during the hearing about Mr. Davis was getting out of the car, or the officers raised that. Well, he got to where he was going, so that's why he was getting out of the car, and the detectives kind of, not pinned him in, but
Sure.
pulled up next to him, so he certainly wasn't free to leave. So his first argument is that they didn't have any reason for the initial pursuit, going back to when they observed Mr. Kareem. And the second
Well,
argument,
the equipment violation is alone enough, the tint violation. They could have stopped him at any point along that journey. They were following him to look for other violations, which is perfectly legitimate.
yes, Your Honor, and ultimately there were no, and it's interesting to note that there were no citations ever given for the tinted windows, but that
Doesn't matter.
And that's what Judge Gilbert had said in his ruling. But also, Your Honor, we argue that the stop was prolonged unnecessarily once it happened because Mr. Davis was asked for insurance. He was unable to provide proof of insurance for the car that he was in. He did have some proof of insurance for another car that was owned by Mr. Marshall.
That's why I didn't see this as a prolonging case, even though there's some talk about the dog in the background. They never resolve the insurance issue, and that's well understood to be a legitimate part of the police initial inquiry.
Your Honor, I would assert that I agree with the court that they can ask for insurance, but my experience with clients is if they don't come up with insurance right away when the officer asks for it, they get a ticket and they should be able to go on their way, that shouldn't necessarily be a reason to prolong a stop while somebody is digging for an insurance card or saying that they do believe that they have insurance. Usually, here's your ticket for the insurance, the tinted windows. Have a good evening.
But
sir.
would you say it's the same case if the police stop you and they say, license and insurance, and you and you give them your driver's license, but you say, oops, I don't have the insurance card with me. It seems like that's a pretty straightforward, maybe just write the ticket and go. But this was more complicated. This was a proffered insurance card that's for an entirely different car, and they're also having problems figuring out how the VIN of this car, because it's silver versus black, and they have things that are disturbing to them that they're trying to resolve. So it seems like that's different from just saying, I don't have my insurance card with me.
I agree. The car had been painted, and they were looking into that.
Right.
My assertion would be that they had already asked for the dog to come before they started doing all that. So,
but then they find out the dog can't come, right?
and they did find out the dog was not available. They thought my client was acting nervous. We would argue that those.
They always think that.
And my assertion or argument would be that the subsequent investigation for the insurance, the VIN number, and all those things that occurred thereafter were really just means of prolonging the stop because they felt the officers had a hunch, which of course wouldn't be here if it wasn't, but they were right. There was something wrong afoot, but that's why that they use those means to prolong the stop. So that was our argument on that. So we're asking that the court suppress the evidence that was seized based on those arguments. Thank you.
Thank you. Mr. Sanders.
May it please the court, counsel. My name is David Sanders, and I represent the United States on appeal. The district court correctly denied defendant's motion to suppress. As the court knows, the reasonable suspicion is a minimal standard here. It permits a brief investigation upon an objective and particularized suspicion. Here, deputies noticed the tint the vehicle had illegal tint on its windows and on its brake lights. They later learned that the registered owner had a suspended driver's license, and there were no facts here negating that the reasonable inference that the registered owner was likely the driver. As such, the traffic stop was constitutional based on those three independent justifications. As to defendant's second argument about the prolonged stop, in grants, it was only 8 minutes. The traffic stop, the mission of the initial traffic stop never ended because the situation changed, and it changed drastically. And that's why it went from an ordinary traffic stop to now to a drug arrest. Accordingly, the district court properly denied the motion suppressed. I would like to address a couple of the questions. There is a meter, Judge Rovner, that was deployed and used later on, that the tint is enough to pull this car over with. And
Well, you're not quite saying that. I mean, they have to have the reasonable suspicion or probable cause ex ante. They can't say, well, it turned out I was right, and so therefore it was okay to pull the car over. So you have to have something. And actually, the district court, having viewed the car, says, yeah, this really looks dark. You know, it was well within the range of reasonable suspicion, or maybe more, for the officers to pull the car over and initiate an investigation of the tint. So, but you can't say that the after the fact corroboration is what justifies the stop.
Correct, Your Honor. And they had that reasonable suspicion based on their observation of being 200 feet away from this vehicle and following it multiple times, noticing that the tail lights were not visible from 200 feet, none less than 500, what is required by statute. Unless there's any further questions, the government rests on its briefs and urge affirmance. Thank you.
All right, thank you very much. Mr. Cohen, anything else?
No, Your Honor, if there's no further questions, I don't have any. Thank you.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our next case this morning, Grady versus Truett. Ms. Mannion.
May it please the court, counsel. My client's prior counsel failed to raise a critical and meritorious issue on appeal that would have made all the difference to my client. She failed to challenge the sufficiency of the evidence to convict Mr. Grady as a felony murderer, as a first-degree murderer, as a shooter and a killer, when we know that the evidence was insufficient to sustain that conviction. We know this because...
But do we know this? I mean, this gets us into the law regarding inconsistent verdicts. And the Supreme Court has said when they're inconsistent, Ms. Powell, we don't know, which one was right. So even putting to one side ways that you might, in fact, reconcile these verdicts, let's just assume for the sake of argument that they're not reconcilable. You still don't know which one is right. And so what we have to do is apply this test. Did appellate counsel at the state level bypass a more promising argument, namely the one that you're making, in favor of less promising arguments? And the Illinois courts seem to have thought that he wouldn't have gotten anywhere on this inconsistent verdicts point.
So on that point, Your Honor, it is true that cases such as Powell from the Supreme Court and People v. Jones, frankly, from Illinois, both say that when you have a situation of independent counts pled in a single indictment, they could have been brought as separate indictments. They weren't, right? Where you have separate counts brought within an indictment, or separate counts against a co-defendant, for example, that there's some speculation there. You don't really know which one was the right verdict, right? The acquittal or the conviction. Respectfully, we would suggest that that's not the situation. This situation is more akin to the federal authorities that we point out in our papers. This is cases from the 5th and 6th Circuits, U.S. v. Gonzalez, U.S. v. Randolph. And what those cases say is, hey, we're actually not in Powell territory. What we have is not so much inconsistent verdicts. The better framing of this is an internal inconsistency. The state chose to present a substantive offense and bring a sentencing enhancement on top of that as a special allegation or a special interrogatory. And when the jury made a finding, a negative finding in response to that special interrogatory, you can't just disregard it. You need to give it effect. That's what Gonzalez says, and that's what Randolph says. And that's true whether it negates an element of the crime, which is what we see in some of the federal cases, the drug conspiracy cases, or where it negates the theory of guilt being prosecuted. That's the Gonzalez case. And we would respectfully submit that the state here pursued a single theory of guilt, which was he was the shooter. My client was the shooter. And when the jury found in no uncertain terms in response to in response to the special allegation that no, he was not, the state failed to prove that, then that finding had to give effect, and it gave effect. It was internally inconsistent with and cannot coexist with the general verdict finding.
There was an aider and abettor alternative submitted to the jury.
So, Your Honor, do you have something, Judge Rovner? Okay.
No, that was my question as well.
Sure.
Sorry.
So, yes, there was an instruction on accomplice liability as an aider and abettor. We would suggest that that cannot save the conviction or mean that counsel was necessarily constitutionally adequate in this scenario for a couple of reasons. First, the tendering of that instruction we think was improper. That admittedly is not before your honors this morning, but the state said again and again and again, he is the shooter, he is not the accomplice, the co-defendant is the accomplice. So there should not have been a accomplice liability to begin with. The reason for that, and brings me to my second and more...
Did Grady object to the jury instruction?
It was a contested tendering, Your Honor.
Oh, okay.
It was there, though, however, and we're not disputing that.
Right.
See, that's the problem. You know, I can follow a lot of your argument, but once we have the jury permitted to find accomplice liability, all of the pieces seem to fall in order, and it seems a jury could have found that the two of them were both involved, and that even if, you know, Mr. Grady wasn't the trigger man, he was sufficiently implicated for the accomplice liability, and so everything fits. And it's not a separate offense. I mean, under Illinois law, actually, it's common. It's not a separate offense, so it was charged.
Yes, so it was in the instruction, but we would submit, Your Honors, that if you look at the transcripts, the only competent evidence that would support aiding and abetting theory for felony murder is the testimony of the co-defendant, Aaron Bronson.
Right, but you know, we all have seen these kinds of co-defendants. Mr. Bronson had every incentive to say whatever he thought he could get away with, but nonetheless, the jury we trust juries to evaluate those things.
Yes, and we would submit that the special verdict finding actually shows that the jury did not believe Mr. Bronson. His whole narrative was Mr. Grady, my co-defendant, was the shooter, he shot him. What do we know from the jury finding? The jury didn't believe that. They didn't buy into that narrative. He was so significantly impeached and incredible that we know from the jury they didn't believe him. Nonetheless, they did enter a general verdict finding against my client. We would submit rather that there was no competent evidence that would support an aiding and abetting for felony murder. More than that,
can we get back to sort of the Sixth Amendment lens? Because I think you don't want to fall into the trap of thinking that we're here to decide the merits in a way. We're here to consider whether appellate counsel was constitutionally insufficient for failing to present this. And the only reason we're in this other discussion is because there wouldn't be any prejudice if it was a doomed argument anyway.
That's correct, Your Honor. And we believe what made this so obvious and so clearly stronger than the technical sentencing challenges that she chose to pursue was this very split verdict that negated the theory of the offense being prosecuted by the state. It was essentially the state's sole theory of guilt. He was the shooter. The jury found he was not. That was an obvious discrepancy combined with the lack of other eyewitness testimony and the lack of any direct forensic or other direct evidence that would support a finding of guilt against Mr. Grady. That was an obvious thing that should have been raised on appeal, and it was not, and we think that it prejudiced Mr. Grady in the extreme.
So before you sit down, I would like your comment on the state's argument that this argument that you're now making is procedurally defaulted.
On that point, Your Honor, the sufficiency, the claim that has been presented throughout the state court proceedings, throughout post-conviction, was always a Strickland claim based on insufficient evidence to sustain a first-degree murder conviction. Part and parcel of that was the inconsistent verdicts. Now, was there different emphases throughout the post-conviction papers? Yes, but we think that that is cognizable and is defensible under cases from this court, such as Sweeney, which basically says, so long as the substance is there, reformulation is okay. We cannot expect a carbon copy of the claim to be preserved throughout the state. We believe the state courts, it has been fairly presented, and in any event, it was waived in the district court below. As we know, procedural default is an affirmative defense. Instead of claiming procedural default before Judge Rowland, the state decided to engage in the merits, therefore it would have been waived. And
Thank you.
if it's okay with Your Honors, I'd like to reserve the rest of my time for rebuttal.
That's fine. Mr. Fisher.
Morning, Your Honors. Counselor, may it please the Court, Assistant Attorney General Garson Fisher for the respondent. As Your Honors have noted, there are two independent bases on which this Court could deny habeas relief in this case. First, because the specific basis for ineffective assistance of appellate counsel that petitioner advances in front of this Court was not one that was pursued through a complete round of state court review. And second, because the underlying basis for the current ineffective assistance of appellate counsel claim, namely that petitioner's murder conviction should be overturned based on inconsistent verdicts, is meritless. Indeed, the claim was undoubtedly raised in the state post-conviction trial court. That court held that counsel was not ineffective because that underlying claim was meritless, and because counsel cannot be ineffective for failing to raise a meritless claim. The trial court's holding that counsel is not ineffective here is not objectively unreasonable. Under Illinois law, inconsistent verdicts does not provide any basis for reversing a conviction. The Illinois Supreme Court has held that. Illinois courts have since held you can't get around that rule by recasting your inconsistent verdicts claim as a sufficiency of the evidence claim. And indeed, they've held that that rule applies even in a case like this one where even if there was no suggestion at all of a co-defendant or an accomplice. So under Illinois law, for example, if you had a case where there was clear video evidence placing a victim in an otherwise abandoned parking lot, the defendant approached the victim, pulled out a gun, shot and killed the victim, walked away, multiple eyewitnesses, let's say that that was what had happened, and the jury found the defendant guilty of murder, but declined to apply the firearm sentencing enhancement under the special interrogatory, that would not provide a basis under Illinois law to reverse the murder conviction. There's a couple reasons for that. One, we don't know that that means that the jury found that the defendant didn't kill the victim. Perhaps the jury, as the Illinois Supreme Court has noted, was engaged in some kind of jury nullification. They felt that the murder conviction imposed sufficient criminal liability on the defendant and didn't want to create greater sentencing liability by finding that he personally discharged a firearm that resulted in death. Moreover, it's even clearer why we don't hold the finding on the special interrogatory against the murder conviction in a case like this one, where they're not even inconsistent. As Your Honor noted, there was an accountability instruction. The accountability instruction clearly and correctly articulated accountability law under Illinois law. The element that the jury would have had to find to impose the firearm and sentencing enhancement is that the petitioner personally discharged a firearm. To find him guilty of murder, they had to find that defendant or one for whom he was criminally legally responsible had committed the acts that resulted in the victim's death. Which is to say, the jury didn't have to find petitioner guilty of murder beyond a reasonable doubt that petitioner himself killed the victim.
And Bannon pleads, right? You know, Bannon has the 25-year sentence.
I'm sorry.
The co-defendant.
Yes,
pardon.
Bronson pleads guilty. Yes,
sorry, Bronson.
I believe that's his name.
Yeah, no, it is his name. I'm sorry. But he pleaded guilty.
Yes, Your Honor.
And got, for his cooperation, a favorable sentence.
Yes, Your Honor. But his statement is corroborated by video evidence at the casino that shows petitioner approaching the table where the victim and his colleagues were winning money, by the petitioner's cell phone, which is found at the scene of the murder, by the firearm used in the murder, which is found in petitioner's apartment, along with a photo that matched the photo on petitioner's cell phone, as well as eyewitness testimony that is consistent with the course of events that Bronson described. So the jury they didn't have to find petitioner beyond a reasonable doubt that petitioner killed the victim. They didn't have to find beyond a reasonable doubt that Bronson killed the victim. The jury didn't even have to agree on which of the two of them was the murderer. And in fact, any individual juror could have been uncertain which of the two was the murderer, so long as they found beyond a reasonable doubt that either petitioner or Bronson, and not some unnamed third person, had killed the victim.
Sounds like a compromise verdict to me. I mean, it's the only trouble with this, which I think is what your opponents are focusing on, is the state didn't argue any of this, in the trial.
Two responses, Your Honor, to sort of the two parts of the question. First off, I agree. This very well might have been a compromise verdict. We find him guilty of murder, but either we don't want to impose the greater sentence, or maybe Bronson told the truth, except when he got to the part where he sort of exonerated himself from actually getting out of the car and pulling the trigger. So we're not totally sure about that part. But one of the two of them did it, not some third person. We find beyond a reasonable doubt they were responsible for each other's conduct, and therefore we've got a guilty verdict on murder. We're not sure about this personal discharge. That's absolutely what this feels like, and it is certainly a possibility, which is why these inconsistent verdict kind of cases don't provide a basis for overturning the murder conviction. It is true that the state argued in closing throughout trial that petitioner pulled the trigger, but of course the prosecutor's statements aren't the evidence. The jury is clearly instructed on that fact, and that the evidence is the evidence. The jury was instructed at the state's request on an accountability theory. The evidence is plainly sufficient, viewed in the light most favorable to the state, to support a conviction on an accountability theory. So if the argument is a sort of general counsel should have challenged the sufficiency of the evidence in this case kind of claim, that is clearly not stronger than the claims that were raised. The evidence here plainly was sufficient, viewed in the light most favorable to the state, to convict the petitioner. It's also worth noting that the district court addressed an ineffective assistance of appellate counsel claim on a sort of generalized sufficiency kind of claim basis, rejected it, did not grant a certificate of appealability on that question. Petitioner asked this court to expand the certificate of appealability to cover that sort of generalized sufficiency question. This court declined to do so. Illinois courts are clear that inconsistent verdict cases and sufficiency cases are separate questions under Illinois law, and that you can't receive relief on this kind of inconsistent verdict kind of argument. So petitioner can't simply sort of label this a sufficiency case and take this inconsistent verdict claim, which was plainly foreclosed by Illinois law, and so counsel was not ineffective for failing to raise it instead of the claims that were raised, and replace it with a general sufficiency claim. But even if...
But almost nothing was raised. I mean, just excessive sentence and this little tiny correction that does get made.
Sure, and I mean, At least, Your Honor, those claims weren't expressly foreclosed by Illinois case law. And since the standard is, was this claim obviously and plainly more meritorious than the claims that were raised, on that front, it is not. But in any event, counsel can't be ineffective for failing to raise a meritless claim, and this claim clearly was. I mean, it is worth noting, I think that this is properly labeled. The underlying claim, the inconsistent verdicts claim, would be properly addressed as a state law claim, frankly. The question is whether, guilty verdict on murder and not applying the firearm enhancement, both of which are Illinois statutes, creates an inconsistent verdict such that you have to overturn the murder conviction. That's an Illinois law question. The post-conviction trial court held that that underlying claim was meritless. This court can't review that state court determination of state law. So once we accept that that underlying claim was meritless, it was not objectively unreasonable for the court to hold that appellate counsel wasn't ineffective for not raising it. Unless the court has any further questions, we would ask that this court affirm the judgment of the district court.
Thank you.
Thank you, Your Honors.
Ms. Mannion.
Thank you. A few points, Your Honors. First, as to the existence of the accountability instructions and accomplice liability theory, particularly, we would point the court to the fact that we also have an estoppel issue here, and that was not raised in counsel's argument. We put it in both our affirmative brief and the reply. Here we have an issue where the state, in opposing on direct appeal in the state court, the state walked away from any idea that accomplice liability could possibly have served the basis of the conviction here. In opposing the excessive and rather defending the sentence that was imposed for 60 years, the maximum for first-degree murder, the state affirmatively opposed this theory that accomplice liability served a role, and they won, right? So they make an affirmative position, they won on it, the sentence was affirmed. It was only here in federal habeas proceedings that the state is now taking a pivot to say, oh, no problem, it could have been a conviction for accomplice liability. We think estoppel principles play some role here, and that should prevent this about-face by the government, and we point the court to the Palmer case for that proposition. Two related issues, Your Honors. Was this idea of inconsistent verdicts expressly foreclosed? We think not. There is case law such as People v. Peoples and People v. Allen. We think they're factually analogous, and those types of cases should have been researched and cited by the appellate counsel in raising a direct appeal, not only just technically to the sentence, but to the underlying conviction. And finally, just sort of a technical point about expanding the certificate of appealability. It is true that this court denied a review of the excessive sentence challenge and then also for prosecutorial misconduct. I don't think, however, that there was ever sort of any delineation between a sufficiency challenge strictly predicated on inconsistent verdicts versus inconsistent verdicts plus the sufficiency of the trial record. And for that reasons, we think it's appropriate for your review and that the Strickland claim is viable, the writ should be granted.
All right, thank you very much. Ms. Mannion, I believe the court appointed you or recruited you to represent your client in this case, and you have our thanks for your representation and your service to the court. All right, thanks to you too, Mr. Fisher, and thanks to all counsel. The case is taken under advisement. We'll move to our next case today, Ferris versus Vector Construction. Ms. Reichman.
Good morning, Your Honors. May it please the court, counsel. The district court erred in dismissing Mr. Ferris's claim for wrongful termination in violation of the Americans with Disabilities Act. As alleged in his complaint, Mr. Ferris discovered his termination for the first time on October 25th, 2018, and he filed with the EEOC within 300 days. Applying the well-established discovery rule, his charge was therefore timely. Mr. Ferris's claim for wrongful termination was sufficient on its face. Mr. Ferris was pro se in the district court.
He used the Central District of Illinois form complaint and checked the appropriate boxes for wrongful termination in violation of the ADA. And he alleged that, quote, 10/25/2018, I learned I had been terminated, end quote.
So let me ask you this question, Ms. Reichman. We all can see that there was the date when he's told, don't come to work, August 5th, which you're characterizing as the layoff date. So he knows he's been injured by the company as of that date. Then he finds out in October that he's actually been injured on the very same date, the very same events, more grievously than he thought he had been injured. He thought it was just a layoff. Now he finds out it's a termination. Why doesn't the rule that the statute of limitations runs from the date you know you were injured, even if you later find out that there are additional injuries, why isn't that the rule that applies here?
Yes, this is a claim for wrongful termination, and when he was laid off, it was a completely separate injury from his termination. When he was laid off, it wasn't any kind of termination of his employment relationship. In the construction industry, and in Mr. Ferris's experience working for Vector Construction for 22 years, he had been laid off each of those 22 years temporarily as work became available. Based on that, he had no notice of the fact that he was terminated when he was temporarily laid off from this job. When he was temporarily laid off, he was simply laid off from the current job that they were working on, sent home, but he had information that he'd be called back as soon as December for a new job. So he had no notice of his termination.
But you are still deriving from this act of sending him home from work until further notice. I'm trying not to use terms that are terms of art. That is maybe not even an injury, a layoff, and he only finds out he's injured. He says now we have to sort of correspond this to his charge too with the EEOC. Your opponents say that the charge didn't focus on the termination.
Yes, to clarify, Mr. Ferris did not say that he wasn't injured when he was laid off, but the claim that we're preserving is for the wrongful termination. And when he was laid off, he simply had no notice of the wrongful termination. And this court ruled in Draper v. Martin that the date of the unlawful employment practice is when a final, ultimate, and non-tentative decision is made for which the employee receives unequivocal notice. So although he may have suffered some injury when he was temporarily laid off, he had no notice of the injury for the claim that we're preserving right now.
So you're having to argue that it's just completely different. Oh, excuse me. Go ahead, Judge Roper.
Oh, okay, thank you. Whether he can sit, all right. He was sent home, and he was precluded from working anymore. Now, whether he considered that a discharge or a layoff, he was aware of the discriminatory act at that time. And a claim accrues when one suspects discrimination, not when all of the surrounding information is known. Am I not correct?
You're correct. So if he had sued for a claim for wrongful layoff, it would have accrued when he was sent home from that job. But when he was sent home from that job, he had no notice that his employment relationship was permanently terminated. He only received notice for the permanent termination in October, and he had no reason to know, based on that layoff, that he would be terminated. So he did not receive any kind of notice of his termination until later in October.
Your argument completely recharacterizes the claim that was asserted in the EEOC charge.
So can I clarify? The EEOC charge asked for the last date of discrimination. He wrote August 5th. This was based on the fact that in October, when he emailed the supervisor of the overseer of his 401k account, trying to take a loan from that 401k account, assuming his employment had not been terminated. On October 25th, the loan administrator told him, the account administrator told him that he had been terminated a couple months earlier. That Vector had just told the account administrator that he had been terminated a couple months earlier. Based on this, his best guess of when he had been terminated, because he was never given a clear termination notice, he was never told a clear date of when he was terminated. Based on this, he guessed that his termination had occurred in August, based on the fact that in October, he was told he had been terminated a couple months earlier. He put August 5th on the EOC charge, but the EOC charge didn't ask for when he discovered his termination. It only asked for when the termination occurred. A cause of action only accrues when the employer discovers or should have discovered the injury. So his EOC charge form is actually completely consistent with his complaint, where he said that he discovered his termination in October.
But he complained about a job action, an adverse employment action that occurred on August 5th. And that's what the EEOC charge was about. And it has somehow morphed into a different sort of a claim on appeal. And I'm struggling with that disconnect because the case is limited by the EEOC charge, and the EEOC charge focuses on an adverse employment action that occurred on August 5th. The 300 days starts running then. He clearly knew he had suffered an adverse employment action. He clearly knew that it was discriminatory. Clock starts running.
In his
And
EOC
if he
charge,
wanted to litigate something else, then that's a different EEOC charge.
In the EOC charge, he checked the box for the defendant intentionally discriminated against plaintiff by terminating the plaintiff's employment. In the description section, he wrote that he was discharged on or about August 5th, 2018.
Right.
So he made clear, although he may have spoken about what could plausibly have been claimed in a number of different claims, he definitely included the claim for wrongful termination in his EOC charge.
Right. So the clock started running on that day. He knew as of that day that he had suffered an adverse employment action.
This is in retrospect.
The precise character of it perhaps became clear later, but he knew he had been discriminated against by either a layoff or a termination on that date, and that's the charge he filed with the EEOC, and that's what we're limited to. The clock started running on that date.
Applying the discovery rule to the October 25th
Applying
date.
the discovery rule to the August 5th date, he knew he was injured then, and that's
He knew he was
and the fact
injured.
that the injury, the scope of the injury, or the character of the injury may have become clearer a couple of months later doesn't affect when the clock starts.
No, there were two separate claims. The clock started for the layoff.
That's what I'm struggling with. The two separate claims here is not what was within the scope of the EEOC charge. You're saying that there was a layoff on August 5th and then there was a termination at some later point that actually started the clock.
Yes, exactly. There were two separate adverse actions. There was a layoff and there was a termination.
Then you have a problem of being outside the EEOC charge, which defines the scope of the litigation.
He checked the box for a termination in his EOC charge, and he wrote that he was discharged in his EOC charge. He didn't include the information in the actual EOC charge about the later discovery, but he spoke about the later discovery to the EEOC investigator. And based on that, the EOC concluded that it was timely, based on the investigation into the claim and realizing that there actually were two separate claims. If there are no further questions, I would ask this court to vacate the lower court's judgment and remand for further proceedings.
Thank you. Mr. Tews?
Good morning, Your Honors, Counsel. May it please the Court, I'm Matt Tews representing Appellee Vector Construction. Mr. Ferris's claim is untimely and the District Court properly dismissed his claim with prejudice for at least three core reasons. As your honors have already alluded to, the first reason we know that Mr. Ferris's claim is untimely is that's what he says in all of his documentation.
But your position does require us to ignore the distinction between the actual date when something happens, on the one hand, and the time when a person learns that it has happened, on the other hand. Those could be two different dates. And he didn't learn that he was terminated until October, even though the event happened in August. He was just told go home, and he doesn't know whether go home means you've lost your job for all eternity or whether go home means we don't need you this month. Two really different things.
Yeah. When Mr. Ferris was told to go home in August in the middle of construction season during the middle of a job, he knew, or he certainly should have known, that discriminatory action had been taken against him that ended his employment.
Well, let's just stop your sentence right before that ended this employment. I think you may be right. He certainly knows that some adverse action has happened to him. He relates it to discrimination on the basis of disability. I don't think you can go so far as to say a temporary layoff is exactly the same thing as the end of all employment, but then one does need to take into account the principle that Chief Judge Sykes was talking about and that I asked about, that if there's an adverse event, and I mean this happens all the time in tort law, you know, the doctor treats you badly and you think, you know, you just have a badly knit broken leg, but it turns out instead of a badly knit broken leg, there's an infection in there and you wind up losing your leg. So, you know, you thought it was for one problem, it turns out to be for a much bigger problem. But the limitations period runs from the time you discovered that there was a problem at all. And, you know, you may later discover that there's much greater magnitude to the problem. And if this case falls into any category that favors you, I think that's the case. That's the case here. He knows something bad happened to him on August the 5th. He attributes it to disability discrimination. He only finds out in October that actually it's the whole loss of his job where he's worked for 20 years. But if that's really all part and parcel of the first thing, then that might be an important factor.
I believe that's correct, Your Honor. And I think an important distinction here is that this is an at-will employment case. In an at-will employment case, a layoff and a discharge are the same thing because there is no right to a recall, there's no right to be rehired, there's no obligation on an employer to hire the employee back after some time.
I'm not sure I'm persuaded, though, with the course of dealing that that's necessarily true. Now, if he had written a different charge and had, or perhaps, I mean, maybe we should talk about whether he should have been permitted to amend his complaint, because that's one of the forms of relief he's seeking here, to say that in his line of business there was a long practice of work, layoff, and so there was no reason for him to think that one more layoff was the end of his relationship. Only in October did that become clear. There could be facts that might support that.
Respectfully, here's the difference between his new claim that there is no reason for him to believe that his employment had ended in August, and what he says in his charge, and what he says in his complaint, and what he says in his brief, and what he says is in his informal papyrus filing. And that is, he knew on August 3rd that he engaged in protected activity, so says his complaint. Whether it's protected activity under the ADA or some other statute, we can talk about perhaps. But he knew that he engaged in protected activity, and for that protected activity, he was told, get out of here, go home. So to say that there's no reason for him to know that an adverse action ending his employment happened in the beginning of August is, I think, inconsistent with the facts in his complaint and his other documentation. And I would like to point the court to, I think that this makes this case a lot like Lawson and a lot like Caldwell from the circuit. In both of those cases, what the courts, the Fourth Circuit in Lawson and the Caldwell here in the Seventh Circuit says is, when you are terminated from employment, you may think that your employer may remedy that termination at some point in the future, and they may rehire you. And you may even have a good practical reason not to want to suffer further discrimination in a failure to recall case by not filing an EEOC charge based on the initial act of having your employment terminated. But that doesn't change the accrual date. Your injury still accrued on the date at which the action took place. Here,
So that may be true. Let me ask you this sort of random question. He really finds out about the fact that he's lost his employment permanently when he's trying to get a loan from his 401k. So I take it the employer never told him that his rights vis-a-vis his 401k had changed?
that's not in the record, Your Honor. I don't know the answer to that
But we do
question.
know we're not going to work with you because we just found out you were terminated. There's indirect reason to think that something happened with that.
Yes, I mean, when an employee is sent home, if they don't think that their employment has been terminated, they have an obligation to do something, to say something, to find out whether an adverse action has occurred if they don't believe one actually had. That's why there is a new or should have known standard.
Okay, so but you're saying that you don't know anything about the 401k.
I do not, Your Honor, and there's nothing about it in the record except for what was filed in the briefing below.
What communications were made to Mr. Ferris when he was sent home in August? Were they any different? Will the record tell us, were they any different than all of those other layoffs and returns? Did he have any reason to believe that he was being discharged at that time, or was it just one of a whole series of such events? What would be different about this one?
Unless Mr. Ferris would allege, and he has not, that every single time he was discharged, it was as a result of retaliation for engaging in protected activity, it was certainly different than his previous layoff situations, because what happened in August was, according to Mr. Ferris and his pleadings, was an immediate negative reaction to engaging in protected activity, after which he never worked again for Vector Construction. An employee in that situation, at the very latest, knows of the discrimination that has been or that they allege has occurred. And I think I'd point the court to the Supreme Court's Ricks case. And in particular, actually, I'd like to point the court to the dissent of Justice Stevens. Justice Stevens, as he often did, put forth a practical rule. And the practical rule that Justice Stevens put forth was, we shouldn't mess with any of this accrual issue prior to an employee's last day of employment, because it can be ambiguous as to whether or not the employee knew that their termination had occurred. So the last day of employment should be the day that we should just have as a bright line rule that an employment claim accrues. So even in the Supreme Court's most favorable articulation of what the standard for a discriminatory discharge claim could be, it still accrues on the last day that the employee is employed. And plaintiffs do not cite, nor could we find, any case from any jurisdiction that stands for the proposition that an employee who is alleging a discriminatory discharge finds out or discovers any later than the day that that discriminatory discharge actually happens that the claim accrues. And for all of those reasons, we believe the district court was correct in dismissing this case with prejudice, and any attempt to amend would be futile, and therefore it should be affirmed.
All right, thank you very much. All right, Ms. Reichman, your time had expired, but I'll give you some extra time if you have something to say in brief rebuttal.
In Ricks and the other two cases that Vector cites, The plaintiff was told, "You'll be terminated at the end of a certain period." And the plaintiff filed only within the time of being terminated, not within the notice. In all three of those cases, the plaintiff received unequivocal notice that they would be terminated. Mr. Ferris did not receive any kind of notice, let alone unequivocal notice that he would be terminated. He did not find out about it until October, and applying the discovery rule to October, his charge only began to accrue then. Additionally, regarding the 401k loan, Mr. Ferris wrote to the district court judge in his letter reissues on appeal that he had tried to take a loan from his 401k account. So this is in the lower court record, and this court can consider it on appeal.
All right, thank you very much. Our
Thank
thanks
you.
to both counsel, and the case is taken under advisement. And we'll move to our next case this morning. Jack Kelly Jack Kelly versus the City of Anderson. Mr. Burke.
Yes, good afternoon now, Your Honors, and may it please the court. Counsel, my name is Daniel Burke, and I represent the appellant Jack Kelly. The issue here today, Your Honors, is did the district court err in dismissing my client's claims brought under Title 42 U.S. Code Section 1983 for fabrication of evidence and malicious prosecution, along with an accompanying state law claim for malicious prosecution on statute of limitations grounds. We submit respectfully, Your Honors, that the district court did err, and we request that the dismissal be reversed and the case be remanded for further proceedings. The standard that this court has espoused on a number of occasions, and that the district court itself recognized, is that when a 12b6 motion is brought seeking to dismiss a complaint based on limitations grounds, such a motion should only be granted if the facts establishing that affirmative defense on limitations grounds appear within the pleading. In fact, decisions in this circuit have gone even further and said and held that the complaint should only be dismissed if there is no conceivable set of facts that would support a defense to the limitations affirmative defense.
I've really been trying to figure out why she could not have known earlier than April 2019 that Detective Carroll used false information to effect her arrest and pretrial detention, because she accuses him of criminal activity and having a vendetta against her dating back to 2006. And furthermore, she knew as of 2014 that it was Carroll, not Babb, who swore to false statements in the probable cause affidavit, regardless of where the falsehoods originated. So if you can help me with that, that'd be great.
Certainly, Your Honor. The 2006 exchange that you're referencing, at least as far as the complaint tells us, Ms. Jack Kelly is an investigative journalist. She received a tip that Officer Carroll had been engaged in unlawful activities. She contacted Officer Carroll. He became indignant at the insinuation and made certain threats. Many years later is when, I think we're talking 6 years is what the dates in the complaint would show. The allegations are brought against my client. And at that time, I believe the complaint alleges the probable cause affidavit, the police report, and even a deposition that Officer Carroll provided in the criminal proceedings. In all of those instances, he represented that it was Mr. Babb who provided the false information and fabricated evidence, not himself. So the answer to the question, Your Honor, is while it's true that several years before there was a hostile exchange between my client and Officer Carroll, there had been several years that had passed, nothing had happened. And she had no reason at that time to suspect that it was Officer Carroll and not Mr. Babb that fabricated evidence and provided false information.
But doesn't she sue Mr. Babb along the way in 2016?
She does, Your Honor, yes.
Yeah, I mean, it seems, I share some of Judge Rovner's concerns that there's a long time during which she's aware that people are out to get her, and whether it was Babb or Carroll, I mean, there's just a lot of time there for her to find this.
That's a fair point, Your Honor. I would also submit that during this time, she was laboring under the false impression, the false understanding that it was someone else who had provided the false information.
But why does that matter? I mean, it sounds like there would hardly be statutes of limitations if people had to have perfect knowledge of who was responsible for things. I mean, if she sued Babb and it turned out it should have been Carroll, I mean, that would come out in discovery. But there's, I'm not sure what the limiting principle is for the knowledge level you're asking for.
Well, Your Honor, simply put, she was led down the wrong path by misrepresentations by one of the defendants. It wasn't me, it was Mr. Babb. She pursued a remedy against Mr. Babb, and in the course of pursuing that remedy, that's when she learned that no, it wasn't Mr. Babb that had been behind the production of false information. It was Officer Carroll. And then she turned her sights on Officer Carroll, on the City of Anderson Police Department, filing her complaint within 2 years, which we all agree is the applicable statute of limitations here, against those defendants.
There's a procedural problem with your whole argument on appeal, and that is that it's completely new on appeal. In the district court, the dispute was when the proceedings in the criminal case terminated favorably, or in your client's favor. This argument that you're making now about a later discovery of the activity of the fabrication in this deposition, that argument was not litigated below, so that's a waiver.
Your Honor, I appreciate that, and I understand certainly the rationale, the reason behind that argument. I would submit that this court's decision in Sidney Hillman Health Center of Rochester versus Abbott Labs speaks to this issue. That was a case where the plaintiffs at the district court level made equitable arguments in response to a motion to dismiss based on limitations. Their arguments were in vain. The motion was granted. On appeal, they shifted course, much like Ms. Jack Kelly has done here, focusing on the reasonableness of the discovery of their injury. And as the appellees have done here, Abbott Labs argued waiver, and the district court, this court, rejected that argument, noting that even if those arguments had not been advanced in the district court, the plaintiff appellants retained the right to challenge the legal reasoning, the legal theory upon which the district court ultimately granted the motion, noting that
right, but the district court here resolved this motion about the statute of limitations on the grounds that were litigated below, not some preserved alternative. You didn't preserve this alternative, first of all, and the district court didn't resolve the case on preserved alternative grounds. The case was resolved on the grounds that were litigated, which were when there was an argument about when the proceedings in the criminal case terminated in your client's favor.
Your Honor, I understand that.
So the case you're citing is completely not on point.
Your Honor, I would submit that the broader concept espoused in the Sidney Hillman Health case about it being well settled that a litigant has the right to challenge the basis upon which a district court has reached its determination, and noting in that case that
The district court here resolved this case on the date, on the dispute about the date when the proceedings terminated in your client's favor. There was no ruling on this alternative argument about discovery of the scope of the fabrication in a deposition of Mr. Babb. That's entirely new on appeal. So there's no broader principle in play here.
Fair enough, Your Honor. I see my time's running out.
So the argument is waived. You're conceding that?
I'm not conceding that, Your Honor. I would stand on the argument that the
What's your backup argument against waiver, since that case that you're citing doesn't apply?
My backup argument, Your Honor, is that the district court erred in going outside of the pleadings when the standard is deferential to the
district court took judicial notice of public records. That's perfectly legitimate. There was no going outside the pleadings.
Well, understood, Your Honor.
Do you have another backup argument?
The standard on a motion to dismiss on limitations grounds is designed to be deferential to the plaintiff. If there is any conceivable set of facts upon which the limitations argument can be rejected, then the motion should be denied.
So what is the alternative conceivable set of facts that was not waived? Is there any?
The only fact,
any other conceivable set of facts about when the proceedings in state court terminated in your client's favor?
In response to the motion to dismiss, my client did submit records indicating that the criminal proceedings had terminated at a later date.
Those were not records that were capable of judicial notice because they weren't certified. The actual certified record of the state court proceedings support the date advanced by the defendants here and found by the court.
Your Honors, I thank you for your time. I will rest on our argument and briefing, and again reiterate our request that the dismissal be reversed and the case be amended.
Thank you.
Thank you.
Mr. Linnane.
Thank you. May it please the court, Mr. Burke. My name is Tim Lannon, Assistant City Attorney for the City of Anderson, representing all the defendant appellees in this matter. The district court's order granting the motion to dismiss was correct because the court determined, based upon the face of the complaint, together with taking proper judicial notice, that the plaintiff had pled herself out of court due to the expiration of the applicable statute of limitations. And I think as the court has grasped here, the posture of the motion and the response as it came before the district court, and it's important to understand that there were two important legal principles which were not in dispute by the parties at that point in time. Number one was that the applicable statute of limitations in this case was a 2-year statute of limitations. And the second issue, which was not disputed, was that the accrual of the action commenced upon the favorable termination of the proceedings in favor of the plaintiff. As your honors have noted, at no point in time did the plaintiff argue other than that. She conceded that, and the district court in its order pointed out that on page 2 of the response by the plaintiff, she said she agreed that the accrual date for this cause of action was the favorable commencement of, or the favorable termination of the charges in her favor in the underlying state court charges. So the only thing left for the court to do at that point in time was to actually take a look at, well, what was the actual date for the favorable termination of those charges, which it did properly by way of referring to the certified records of both the Indiana Court of Appeal and the state court. And this is allowed, as your honors know, it's allowed both by virtue of the federal rules of evidence 201B, which says that Judicial notice of facts may be taken where those facts can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. That's also been held to be the case by this court in the matter of Oregon Capital versus Dobbins-Beck, where in that particular case it ruled that as to a 12b6 motion, it was appropriate for the court to take that type of judicial notice. So based upon that, Your Honors, the decision of the court was correct. She pled herself out of court. You have so said that in terms of the waiver. I'm not going to dwell on that too much. We know the cases of Business NAB LLC versus FDIC. This court said it very well and very succinctly. The failure to bring an argument to the district court means a waiver on appeal. Also, Wheeler versus Renopolis, where this court held that parties cannot conjure up brand new legal theories on appeal. And that is exactly what Ms. Jack Kelly is trying to do in this appeal before this honorable court. So, because of the waiver that occurs with those additional afterthought arguments that are being interjected at this point in time before the court, we're left with what was the reasoning of the court in rendering its motion, its order on the motion to dismiss. The order was appropriate. The court discerned what was based upon the agreement of the parties, the applicable statute of limitations, what was the proper accrual date, took judicial notice of certainly the most accurate records that were available to the court at that point in time, coming from the Court of Appeals and the state court, and found that the filing of this complaint was beyond the applicable statute of limitations. And for those reasons, Your Honor, we would ask that you affirm in all ways the order of the district court. Thank you very much.
All right, thank you very much. Mr. Burke, your time had expired, so we'll take the case under advisement and move to our last case this morning, and that is United States versus Christopher Hale. Mr. Pennington, whenever you're ready.
Thank you, Your Honor. May it please the court, Chad Pennington on behalf of the appellant in this matter, Mr. Christopher Hale. Mr. Christopher Hale seeks reversal and remand of the district court's 240-month custodial sentence for two fundamental reasons, Your Honors. First, the district court procedurally erred in not properly situating or comparing Mr. Hale's 240-month sentence with comparably situated career offenders. And second, the actual duration, the amount of time imposed here, the 240-month custodial sentence, was substantively unreasonable under this court's jurisprudence regarding substantive unreasonableness. We'll start basically with the effect of the career offender guideline in this case. That's fleshed out in our brief, but I do think it's important to situate the appeal here with that in mind.
But just to be clear, Mr. Pennington, I did not understand you to be arguing that just as a matter of technical application of the sentencing guidelines, that Judge Grady had made some kind of mistake. You're really arguing, it's a much more ambitious argument, one that would require us to set aside a longstanding rule that once you have a sentence within the guidelines, you have in fact taken care of disparities. They're written with the national market in mind. And instead, it's really more a data-driven approach that you think, as a matter of law, that needs to be taken, because there would be nothing to prevent a district court in her discretion from looking at the data that you're talking about. But no one has ever said she has to. She's communicated and she's worked with the guidelines. She looks at the 3553 factors. She comes up with a below guideline sentence, which we don't usually, if ever, I don't think ever, actually set aside as unreasonably long. So anyway, you've set the table for yourself in a pretty demanding way.
Your Honor, I would agree. This is a fairly ambitious request here. And I would also agree, Your Honor, that with respect to the PSR calculation, there was no contestation raised at the district court level. There was no objection raised. So the finding as to a career offender, that's not before the court here.
Right, that's not before the court, and I mean, it's not a lot below, but it's 22 months below the low end of the guidelines?
Your Honor, that's correct. And the argument is that that level of variance, 22 months, is inconsistent radically with the national trend in career offender sentencing.
Okay, if I could add before you launch into the substance of that, another couple of layers of ambition in your argument here to follow the theme. The argument was waived because there was no such argument raised in the sentencing advocacy below. Nothing having to do with unwarranted disparities, no data-driven argument such as the one that's being raised on appeal. And in fact, the district court asked at the end of the sentencing proceeding if all the arguments of mitigation had been covered, and the response was yes. And that's a waiver under our case law.
Your Honor, I would disagree. I think that with respect to this court's jurisprudence on a waiver, the question has to be construed liberally in favor of the defendant, liberally against the government. The sentencing memoranda that Mr. Hale submitted said that a minimally sufficient sentence needs to be imposed pursuant to 3553A. That would encompass 3553A6, the unwarranted disparity argument.
But that's asking the district court to discern a lot from very few words. I thought you were going to argue that it wasn't raised, but sometimes you call that a forfeiture, which allows us at least to think about it under the very demanding plain error standard, but nonetheless we can think about it. Sometimes it's extreme enough to be a waiver, and deciding between forfeiture and waiver is often done by saying, was there any strategic reason not to raise it? Presumably not. You know, it seems just to have been something no one thought of, I guess. Finding forfeiture under the circumstances would still be hard, but...
Your Honor, I would agree. I think if the court's analysis here is not inclined to go under the waiver doctrine, we do believe that there at least has been enough here established where the court can review the challenge under the plain error, understanding that's deferential under the findings of the district court. There still is some modicum of appellate review based on this record here.
So is it your view, having not raised the issue of sentencing disparities as compared to other career offenders, that the judge erred by failing to raise it sua sponte?
Your Honor, the obligation to raise an unwarranted disparity argument is not something that the district court needs to address sua sponte. It needs to address it as a matter of assessing the statutory factors of sentencing. And when its variance is so inconsistent with the national trend with respect to career offender sentencing, it has to articulate a sufficient explanation, a basis for why the variance was imposed.
So the judge is supposed to do all of that research for the defense counsel and make the argument for the defense counsel that there's an unwarranted disparity here, and that's why I'm going to go even lower than I was originally inclined to go from under the guidelines.
No, Your Honor, I don't think it would be appropriate. I would agree that the district court doesn't advance an argument.
Well, that's what a win in your favor on plain error review would communicate to the district judges, that this is a pitfall for them, and if they don't anticipate this argument, even when it's not raised, and if they don't raise it themselves and do all that research and come up with a data-driven argument about national trends, which is basically the argument you're making on appeal, then they're going to get reversed.
No, Your
Because
Honor,
plain error review.
I would think that the standard, and I didn't mean to cut you off, Your Honor, the argument that we're expressing here is not that they need to advance a particular argument, review a particular set of data points. It's that they have to consider the disparity under 3553A6. That's statutory obligation for the court to consider.
That's implicit in a correctly calculated guidelines range, that the court considered it. Black letter case law.
That's correct, Your Honor. That if
that argument fails. Next.
Your Honor, I would say that with regards to whether the court has to consider sentencing data,
It's not the argument. It's more refined in the sense that it has to consider whether the sentence imposed is consistent with the national framework or the national trends within a particular type of sentencing. So it doesn't have to consider the data. I know that's foreclosed under, at very least, the Oregon case that came out recently. Although I do think that case is factually distinguishable, I understand the premise of law that is derived from that case. What we're saying here is that the court does have an obligation to consider unwarranted disparities, and they have to situate that analysis within those national trends.
I did not hear an argument or an answer to my earlier question about why this isn't a waiver rather than a forfeiture.
Your Honor, I think it's not a waiver because there was the issue raised of what is the minimally sufficient sentence appropriate.
That's a very generalized argument. That's not a specific argument about unwarranted disparities of the sort that you're raising here.
Your Honor, I think construing the standard liberally in favor of the defendant, I do think it's
You can't
adequate.
rely on that broad principle. You have to give me something specific within the context of Perez, which is our waiver case, where the district court specifically invites the defense attorney to identify arguments that were overlooked.
I think,
and the defense attorney says, "No, you've addressed everything, Judge."
I
Under
think
Perez, that's a waiver of any argument omitted.
Certainly, Your Honor. But I do think it's distinguishable here. One, the district court in this case is, if I addressed your principal mitigation arguments, the defense counsel says
Those are the
yes.
only ones the judge needs to address under our case law. Non-principal arguments can be passed over in silence.
And furthermore, Your Honor, I think the difference here as to waiver is that the sentencing advocate at the trial level says the sentence should be fashioned appropriately under 3553A. I do think that when she raises that particular issue, that forecloses a finding that there's a waiver here, Your Honor.
How can that possibly be the case? A general statement to follow the law, Judge, in imposing sentence is enough to preserve any argument under the sun? That's preposterous.
Your Honor, I think that the difference that happened here is that when the judge asked if I raised any of your principal mitigation arguments, I think it's important to note that the defense counsel says yes, but that's not necessarily an agreement with the district court's finding. It's just simply saying that you address those arguments.
Right, which means you've waived anything that was omitted. If you have a chance to point out to the judge that the judge has overlooked something, that's the time. And if you don't raise it, then review is foreclosed.
But that does mean that you had to have thought of the argument, and the world of forfeiture involves arguments that everybody overlooks. Sometimes the court overlooks it as well as defense counsel. So that's the question is, how specific is that question, and is that question enough to inoculate against forfeiture when somebody has just flat missed the boat, which is what forfeiture is about. There's no intentional relinquishment of a known right. It's not a situation where you attack this but not that. Those are situations where we definitely infer waiver because we assume there was a strategic reason to attack one point versus another. Forfeiture is different.
I agree, Your Honor, and I think at the very least, Judge Sykes, if the court was to conclude here that there's a waiver, I understand the court's rationale on Perez. I do think at the very least that there's a basis for review under the plain error standard.
By which you mean it's forfeiture.
By which I mean forfeiture. Exactly.
Okay.
Pardon me.
Let's
By which
keep
I
our
mean
terminology correct.
Yeah.
Thank you.
Okay. Thank you. Mr. Temkin.
Good afternoon, Your Honors, and may it please the Court. Eli Temkin for the United States. I'll be brief. This Court should affirm Mr. Hale's below-guideline sentence. It was both procedurally sound and substantively reasonable. First, on the procedural point, Mr. Hale's now arguing that the District Court needed to consider potential sentencing disparities that he points to national statistics on. He didn't present that to the Court below. And he went further and affirmatively waived that argument. To some of the questions the court was asking to my colleague, first, referencing the section 3553A factors generally does not sufficiently raise every argument within excuse me, that could possibly be within those factors. If that were the case, then a lot of cases finding waiver would all be wrong. A defendant, as this court's case law holds, a defendant needs to specifically identify an argument to present it to the district court. Next, onto the point about waiver versus forfeiture. I believe this is the first time that the defendant has mentioned forfeiture and plain error. He hasn't argued that this was just a forfeiture, not a waiver. His argument has been that he presented the argument sufficiently instead, and didn't fail to preserve it at all. I just addressed that point. I won't go back to it now, but there's no basis to find that this was just a forfeiture. To Judge Wood's question about whether there would be any strategic reason not to raise this argument, and did counsel just miss it, the court has never even nodded towards this kind of statistical analysis. The court has repeatedly held that considering an accurately calculated guidelines recommendation satisfies any obligation under Section 3553A6. The court has also held that when faced with these types of statistics, the district court isn't required to conduct that analysis. The district court here did exactly what it was supposed to do. It conducted an individualized analysis, and even on their own merits, the statistics that the defendant is now raising do exactly the opposite of that. Just briefly on the substantive reasonableness point, this court has never held that a below guideline sentence like this one is substantively unreasonable. The district court had good reasons based on the nature of the offense, the multiple drug sales here, and Mr. Hale's long criminal history with 3 career offender predicates at this point. Unless the court has any questions, the government asks that this court affirm Mr. Hale's sentence. Thank you.
Thank you very much. Mr. Pennington, your time had expired, so we'll take the case under advisement, and that concludes today's calendar. The court will be in recess.